Audio check. Audio check. Audio check.
This matter was last listed on 13/8/25.
My lords, I am for the
Written-
respondents.
there's
Respondent
no
number 2 and 3.
We'll give a date.
Lords, great.
My lords, the urgency in this matter is, my lords, that there is a fresh application moved by us. My lords, there was no stay granted by lordships of the impugned order. Lordships had granted us granted leave on the 25th of February 2025. My lords, the urgency is that behind our back, the society has entered into a new development agreement with another builder, my lords. And my lord, since 2002, the development agreement was executed in my favor. I have paid the.
You're mentioning first time mentioning matter,
Yes, my lord. Before my lordship's court.
we can realize.
No, my lord, the gravity is very high, my lord, and I am worried.
Please.
I'm sorry. I'm
Only for fixing a date. Don't argue the case.
Lordships.
Give कोई date दे देना.
Any returnable date, my lord? Very grateful. Very
Next.
It's a 2014 matter, my lord.
grateful, my lord.
In 2014 SLP, my lord, give a,
Selfie.
yes,
What do you
2014,
want? Just stick
some date.
date there.
May please, your lordship, 804, but,
5th of May,
5th of, great.
not to be deleted.
With your lordship permission, may I mention item 42 in the list today?
Wait, when it's called, you can mention.
With my lord's permission, my lord, I take my lord's indulgence. This is the second time, my lord, I am just seeking a correction of an order, my lord, that creates this matter. There was a where, my lord, in our application for direction, which has been erroneously, my lord, written, my lord, whereas the amicus brief, my lord, as well as the application was subsequently rectified. The difficulty is, my lord, had referred all these matters back to the revenue authorities to adjudicate and then for the
So what do you want?
the committee matters to take an appropriate decision. Now, because of this erroneous prayer matters which has been extracted, they are saying that it is a different OA and the prayer is not commensurate with your prayer. So we cannot give you a hearing. So it's just a typo error if in case my lord's name.
In your typo or in our order typo?
The order is appendix.
In your order.
The appendix of my lord's name just.
What did you want? What did your original one say? Survey number 461,
Yes.
46 by 1, respectively situated in so and so,
My lord's.
till the disposal of the suit.
Yes, the OS number, my lords, may have 26333. My lords, the OS is 2633334, my lords. So because
That's
of
the
that,
correction you want.
this is the correction, my
Correction,
lords.
Kal.
My lords may permit, I'll be
Yes.
grateful. Deeply obliged.
Permitted on mentioning so and so करके correction कर ली.
I'm very grateful.
With your lordship's permission, if I can mention item number 28, my lords have fixed it for 2 p.m. specifically, and the learned ASG is opposing us.
Item?
28, my lords. My lords, I am being led by Mr. Gautam Narayan for the petitioners in the matter.
Okay,
His son has met with an accident as a result of
Okay,
which
don't,
he has
don't
had.
bother, we'll accommodate, we'll give some other day.
So, my lords will just keep it for next week or the 28th.
Give a date,
All right.
Let's,
28 note कर लेना.
item 1, my lords, is a common matter in which.
Yes, yes. Similar matters are there.
Yes, my lords.
Post along with that. Yes, आराम से कर लेंगे.
Yes.
My lord, the trial court had dismissed my suit. The first My lord, the trial court had dismissed my suit, your lordship. That the first appellate court, your lordship, set aside the findings of the trial court,
Concurrent reversals.
and yes, and concurrent reversal, your lordship, and the
Consistent
second appellate court, your lordship, then again
Again,
set aside the findings of the high court, your lordship.
बहुत facts में गया है.
Your lordship,
Notice कर लेते हैं.
there is an important question of law involved, your lordship. Your lordship, that is that section 53A of the Transfer of Property Act, and your lordship, the High Court has
Possession.
overlooked section 54 also, your lordship. Your lordship, section 53A bars only the transferor, your lordship, not the transferee. I am the transferor, your lordship. The trial court held that the suit is barred and hit by section 53A. I am the transferee, your lordship. But the suit is barred only for the purpose, only for transferor, your lordship.
So the first and second agreements are there. First was a registered one.
First was the registered CD, your lordship.
Only 87.
87 decimals of land, your lordship, that was a registered agreement. And in that,
Subsequent is not a registered.
in that very agreement, your lordship, it was said that the remaining land will be sold off
40,000 rupees. What is all this litigation about? 40,000.
on the same rate. Your lordship, that was not challenged.
Since 2000 and
That was not challenged, your lordship. That,
why don't you take some money and then close this chapter at this stage?
Your-
Is this a residential plot?
no, this is an agricultural land, your lordship. And your lordship, that sale deed is not challenged, your lordship.
They are in, you have not taken possession from the very beginning.
Your lordship, I am in the possession, lordship. The possession certificate is also issued by the government authorities, your lordship. That is annexure P3.
Notice.
Your lordship, stay may also be given, your lordship, because he is trying to sell off the land, your lordship.
We don't know. We don't know, take out Dasti, because, when is the judgment of the High Court?
At least, your lordship, the
Just
alienation,
wait a minute.
further alienation may be stayed, your lordship.
November 25.
November 25 order. So it's on status quo in the meanwhile. We will only try and see that it is settled, sir. We are not, this is not going to be reversing now after long litigation where the property has not passed. You are still fighting a suit for specific performance, right?
Yes,
Of an agreement of 2002.
Your
At this point of time to execute, having you lost at both stages. Anyway, we'll see if some kind of a money will be
your
given.
lordship, the stay on the
Some written of-
alienation, your stay of further alienation may be stayed, your lordship.
After, we'll see after notice. Next. Let them come.
Much.
The trial court has granted injunction.
But it is
Was-
listed on March.
Yes, my
It's
lord.
directed the case to be listed on March 26.
Lordship,
It must
but
be coming
the-
anytime.
My lord, that case could not be heard. Our problem is this, my lord. They may further sell the property. The trial court has granted it.
Interim order, sir.
My lord, up
It's
to
an
that
interim.
final hearing, my lord, alienation may be stayed. There is only limited.
Ask the court, it is listed immediately. While we are not inclined to interfere. No, this is High Court has listed the case for hearing. When is it? Any date must have been given
My
now.
lord, it is after
You're
2
already
weeks and
barred.
I have received the instruction that the
Done, sir.
case could not be heard.
Dismissed. 5.
The High Court has decided a
This
Yes, Gaurav, what is
High
it?
Court has decided a batch of matters,
Mining lease.
mining lease. Now the facts of the first matter.
Dead rent part of it.
Sorry.
Dead
Yes.
rent, dead rent.
Now question is in my case.
Does it turn on 9A?
Please have 9A, section 22, page 22,
MMDR Act, na?
page 19 minutes. 19.
Here you.
Sorry.
How does it, which is the expression in 9A that you would want to rely on?
Let's just have a look at 9A first.
Sure.
It's quoted at page 19. 19.
Hmm?
Lordship, sir,
Yeah.
the holder of a mining lease, whether granted before or so
One
and
minute.
so,
What?
shall
What are mining lease, whether granted
Yeah.
before?
so and so pay to the state government every year dead rent at such rates as may be specified for the time being in third schedule for all the areas in the instrument of lease. Now, please have the proviso where the holder of such mining lease becomes liable under section 9 to pay royalty for any mineral removed or consumed by him or by his agent, manager, employee, contractor or sublease from the leased land, he shall be liable to pay such royalty or dead rent whichever is greater. Now, 3 facts Lordship may notice below what happened in the impugned order. A batch of matters were decided. Facts of the first matter are taken. Sorry.
Dead rent only.
Facts of the first matter are taken. So the facts
The
of
only thing is that you will have to link the power to impose and collect dead rent.
Yes.
Dead rent
yes
with possession.
with possession. Yes, my lords, I am grateful. Now, in the first matter, the person had a mining lease. His lease was not getting renewed. So the state, in fact, made a statement. If your lordship see state's submission before the court. Now here I have a mining lease, but the possession is not given to me.
It's what, begging the question, right?
Yes.
Once a lease is granted, dead rent is payable. How do you link payment of dead rent with possession?
Because below the rule.
Show from the section.
So the lordship will have rules also, rules of 96, which is quoted also in the High Court.
Interpret rules of subordinate legislation.
No, therefore I
Tell us
was
on the basis of the act. How does
so therefore I wanted to rely on the proviso because the
provided
proviso
that
said
where the holder of the mining lease
yes,
becomes liable under 9
yes.
to pay royalty for the mineral removal. That's the royalty for
That's royalty for the mineral
That's
removal.
different. Or
Yes.
consumed by him.
Yes, my lords.
So therefore, when you remove a mineral,
Yes.
then the royalty will come.
And
But so far as the dead rent is concerned,
correct.
the moment the lease is executed, you are liable to
So
pay.
below suppose
Where does that possession come in? We are just asking you that.
yes, my lords, I'm trying attempting to answer. Central law says lease is executed, dead rent is payable. Lordships are absolutely right. it entails on the government that once it executes a lease in my favor, it will hand over possession to me. That's a condition of the lease.
It's an executive act.
No, that may be an executive act, Willows, but what does the lease entail? Lease entail, I may not mine. Then your lordships are right. You may not mine is your choice. If you don't,
Take, for example, you apply for environmental clearance.
yes, Willows,
You don't get
I don't get
clearance. So therefore you won't be doing it.
absolutely.
But you are in possession, it's a waste possession.
It's a waste possession for me.
Then in which case also you are saying dead rent is not payable?
So therefore that question doesn't arise in my matter, Willows.
You are interpreting the section.
Suppose there's a stay by the NGT. In some
Interpreting the section.
So therefore, Willows, if by virtue of my default, if your lordships have to interpret it,
Holder, when do you get to see the charging provision, so to
yes,
say,
yes,
is on holding.
holding, yes,
Do you hold or not?
correct, right, absolutely, Willows.
Do you hold or not?
So I have a mining lease, but it's a paper document, Willows, because ultimately I'm not able to do anything
The
with it.
lease is executed.
Yes.
The holder.
Willows, in law, I have a mining lease. But the section Willows will not have to consider whether mere having a document.
He files an application under Rule 30. Acquisition complete name. On these was this.
So lordships had a question. Yes.
Application under Rule 30.
So
for
because
declaration of lapse. If on an application an order is passed, then only your liability ceases.
I'm very grateful. Because we filed an application prior to that, which is under 247(5) of the Madhya Pradesh Land Revenue Code, which I'll just hand it over. See, Milos, this is not a land. Yes.
And my brother's question.
Yes, Milos.
The liability will cease when you file an application.
Milos, that's what I was explaining.
Then the liability will commence the moment lease is executed.
Right. Lordships.
Anyway, we'll thrash out this question.
Yes, please do, Milos.
Take notice.
Milos, please take coercive steps, Milos. 73 lakhs has been demanded from me.
Section is very clear, Mr. Gaur.
Milos, just
Section is
the
very
lordship may decide it. Milos, a large number of people.
Take out notice.
Lordship may give out Dasti.
Sure.
Lordship may give me Dasti and some date. Milos, the lordship will thrash it out. It's all right.
There are recovery proceedings initiated against you.
Milos, there is what my learned colleague says, it will go as recovery of land revenue since the High Court, because we had a status quo in the High Court.
Has money ever been recovered through the act?
Plus, if something happens, I'll come back. There's no difficulty. I just told my
Most welcome.
grateful to your lordship. Obliged.
Item 6.
May it please your lordship. Land was sold. Look, this is about 2,400. Yes, surface 2,400 square feet of 4 plots of land in a residential town in Malad,
Finding of fact.
Rai Reddy district. Lord, it
Finding
was
of
sold
fact.
at less than the distress value.
True, but you may be right, you may be wrong, we don't know. It's just a finding of fact, that's all.
Lord,
Whether it is 6.67 is what you declared. It ended up being sold for 5.53. Whether it will be 5.53 or 6 or 4. It's all a fact, sir.
Fortunately, I'm not inviting you to go into facts. If you please see page number 48 is the bank's own valuation report, which is a document filed throughout. If your lordship takes 4.49 page,
Yeah, bank valuation is 6.67.
no, that your lordship would have at page number 58.
But that was way back in 8th May 2018.
Into 8 May 2018 at page 55, 3 values are given. Fair market value is 7.41, realizable 6.67, distress value 5.93. And as my lord pointed out, way back in 2018, this auction was in 2020, property values never fall down. They always go up. And what has happened here is it has been so engineered that lots attempts have been made on paper, no bidder there, and then
2020, huh?
yes, and it should have been much higher. It has come below, and that is why it is not
Very
a question
difficult
of
for us.
fact. Lord, may I then have one recent judgment where your lordship had some thinking on this? May I pass on the judgment to? Lord, if your lordship has
Can you put this also? I've seen it.
page number 20, paragraph 15. Page 20, paragraph 15. at paragraph 15.
We'll hear him. Now tell us.
Paragraph 15. While there can be no quarrel with the settled proposition of rights of bona fide auction purchaser deserve protection, sale should not be ordinarily interfered. It is equally established that such protection is not absolute. Where credible issues are raised regarding adequacy of valuation, fairness of the process relating to fixation of supervisory jurisdiction of the court may be in for recovery pursuit. And in this particular case, what the High Court did was the High Court said, we are not disturbing the auction, but look at the value as on the date of the auction, and if there's a difference, the bidder has to make that. Lord, I am satisfied with that also. This is not a question of inviting my lord to second guess on the value of the property.
We'll leave it at that. Thank you.
Please, my lord, my residential house sold out by the bank only on rupees 18 lakh. However, property value is more than 80 lakh. Let us, my lord, I am ready to pay whole amount. What's happened, your lordship, during COVID?
Go there. Go to the,
Please.
ask for alternative remedy. High Court has said
But
yes.
your lordship,
Don't go in repetition and you will lose both ends. Dismissed. Next.
Item 8.
my lord, only request is let us, my lord, kindly issue notice for mediation. If bank is ready, I am ready to pay, your lordship. Kindly, your lordship, consider this prayer.
If it were a matrimonial matter, we would have done that. Surface matter, what?
Please.
Thank you.
Item 8.
No, my lord, the finding of the High Court that the contempt is barred by limitation is contrary to the records. Kindly see, my lord, the
Contempt.
impugned order.
How is it not?
I'll show you, your lordship.
9th March 2020.
Now, my lord, the direction of the High Court was to consider promoting me to the post of Assistant Commissioner. Now, my lord, what the order was passed on to 2024, my lord, at page 59.
And even that direction was what?
No,
It's a consider the representation direction. You sleep over the matter for how many years?
that now, my lord,
5 years.
now, my lord, I'll tell you, lordship, my lord, the direction was passed in 2000.
We would suggest to him, instead of wasting your time.
No,
but just go and file a writ. There is no
Your lordship may grant me liberty. That's enough. my lord.
What liberty?
Yes, my lord. Your lordship is
Stops
right.
you from doing.
Your lordship is right, my lord. I may be granted.
Withdraw.
I'll withdraw, my lord.
Okay. So seeks to withdraw the special petition to avail alternative remedies. Permission granted. Special petition dismissed as withdrawn.
Obliged.
That's the best thing you could do.
Yes, my lord. Your lordship.
You are right.
Make these balance. This is a classification dispute. Now, it's only 3 short points to canvass before your lordships. Now, it's only 3 short submissions.
What's not submission?
Now, first is the tribunal has not answered the question that the device directly controls any of the equipments in the car. That question is not answered. Admittedly, the functions as prescribed by the tribunal.
What is this equipment?
Yes, my lord, it's a body control unit. What it actually does is, it is
Centralized.
It's
The moment
centralized.
you insert your key, in modern
It receives signals, but only from a
It's a
human
vehicle.
interference.
vehicle, is it? Car.
It's a car, predominantly used in cars.
We know that the moment you insert the key,
Yes.
they
What
are all embedded with the AI.
What it does, my lord, is very interesting. It receives signals and communicates to various entities in the car, which is, for example, the rear mirror, the wiper at the back, the wiper in the front. My lords, these are all receiving signals from this particular product. Now, this product is incapable of controlling each of these apparatus, which controls itself separately. This is merely a communication apparatus which is sending signals to each of these individual apparatus in the car. What the tribunal does is, my lords, it gives...
What are the 2 entries? Automatic regulating or controlling instruments.
Yes.
And second one is programmable
Yes.
controllers is
Absolutely.
what you say.
Yes.
You say programmable controllers.
What it does
big
is,
distinction.
it is predetermined to do what it does. It is coded in a particular way. For example, my lords, if I press the power window button, the BCU receives the signal, sends it to the battery communicates to the window comes down. That's all this device can do. It cannot control the window in such a way that it automatically comes down. The human interference is sacrosanct in this entire process, which the tribunal overlooks.
You amend your entries. You create so much of confusion and litigation.
No, not.
But if the fact that you took so much time to explain to us, how are you expecting people to?
No, my lords.
The way you formulate regulation, these tariff must be clear, easily classifiable.
My lords, with great respect.
And your own
the HSN notes, my lords.
order in original itself has gone against you.
My lords, that is why, my lords, there is a review order subsequently filed directing the commissioner to file an appeal before the tribunal. That appeal has been filed. Now, my lords, that is the impugned order.
That appeal is dismissed.
Absolutely, that, my lords.
Confirmed the order in original.
Yes. Now, my lords, only my last.
Here we were asking you questions, not that we had any doubt about it. We were only wanting to know what this device is.
May I only make one last submission to your lords? The tribunal, my lords, gives a finding that human interference is out of the process. I ask only one question, my lords. Can any of the wipers, can any of the windows in the car function without the driver, my lords, switching on any of the switches in the apparatus? Or at least, my lords, keeping the main function on so that it automatically does it. Without the human, my lords, none of these apparatus can function.
The way to understand is that manual is opening up, unrolling the window. Technology is when you press a button, it will happen.
That button,
that's what it is.
That button is the human interference.
You can't say that. Button does multiple tasks. That's automation. Things don't work with thought.
No, absolutely.
Just why some things will work with blink of your eyes.
What the entry conceives in this case, what the entry conceives.
Thank you, sir.
I leave.
You have a small short delay. Will dismiss on delay or?
We dismiss it on
delay. Dismiss on delay.
Very great.
Yeah.
My lords, I am successful before the trial court. My lords, the suit is dismissed. In the appeal, my lords, I am not heard, my lords.
3 lakh recovery.
My lords, 3.5 lakhs, my lords. Today's, my lords, it's more than 12 lakhs.
You are not denying the signatures on the check, right?
I do not deny the signatures, my lords. I say that I had given it to one person who was managing a
not rebutted. Presumption is not rebutted. That is the finding. What happens if you don't appear despite receipt of notice?
Lords, I had actually, my lords, the office noting of the High Court.
I have not been heard. If you don't appear, this is the result.
No, my lords, I have stated, my lords, in my petition that I had shifted, my lords, in November 2014. And my lords, the appeal is also filed in November 2014.
What about delay of 370 days in filing this?
My lords, they traced me down at the stage of execution proceedings. But my lords, at the stage of appeal, my lords, they don't, my lords, they are aware about my shop address also, they say that. But my lords, they don't contact me during the appeal proceedings. My lords, victorious party is unheard, my lords, at the appellate stage. My lords, now has suffered a judgment. My lords, may send me back, my lords, I'll take my chances.
Not it.
My lords, may at least give me liberty, my lords, my lords, file a recall application, my lords.
Dismissed.
My lords, I'll take my chances in recall.
Nothing. Not
It's a small amount, my lords. My lords, may I take my chances at least at settlement, my lords, then?
Dismissed. 11.
But the petitioners have filed a petition under Article 21 to 29, and respondent has filed the orders of imposing 50 lakh rupees, and both parties went in appeal. The original facts was in 2011 itself. Sisters have filed a suit much earlier to all these proceedings, and petitioners, without before getting the notice on the interim direction IA injunction, they have entered into an agreement. Thereafter, even the respondent also got impleaded in the original suit of 2011. Both parties appeared and they filed vacate injunction.
Clearly collusive, Ravi Shankar. Clearly collusive. There's no doubt about it. Your sister's partition suit is there. Are you unaware of it? This is how it's difficult for us.
It is served after the agreement is entered into.
Clear.
Particularly under Section 9 of the Arbitration Act.
You settle the matter and try and do something.
At least we'll try to.
It's clearly collusive. We won't say anything. High Court has said enough. Thank you. Dismissed.
Made, please. My lords, may only submit similar matters are pending with the same issue. May
Really?
Yes, may only pass the order.
Fine, you're saying it. issue notice.
Because in the impugned order, they have gone purely by tax effect.
Since the tax effect is below this, then that's.
Pending the tax effect is high, is it?
No, no, all matters are low. All in this particular issue, every importer will be low.
Oh, each 53 put together.
Is 1 crore. It's only 1 crore.
Then it is terrible.
No, but in all these matters, well, there's a legal issue involved as Manoj. There's a large scale fraud that is being committed. Now, may I explain the legal issue? That is why Manoj canvassed this point before the other bench, and this is an
identical issue, is it?
Same. And Manoj may see the last paragraph.
Post along with
The respondent in this case is Century. The same entity, Manoj, has sought an intervention in the other matter that is recorded in the order.
Consistency.
Very good.
Once the court issues notice, we will issue notice. Same order.
Very grateful.
Let's kindly see page 8 of the impugned judgment. Clause 6, my lords, can in no way be an arbitration clause. Kindly see page 8 for a moment, my lords.
Escrow account.
Escrow account, my lords. My only case for suit was against the escrow holders for release of those 30 lakhs. That is all my case. That is the only decree. Now, clause 6.
These are the escrow agreement and the original share purchase agreement are very integrally connected to.
No, my lords, may indicate why. That's the error, my lords. The share transfer agreement is between me, I am the seller, and the purchaser. There's an arbitration clause, etc. One of the requirements was there could have been some statutory liabilities in future. So therefore, 30 lakh escrow was done through these two escrow holders, independent agreement completely. And those are two advocates, my lords. In fact, those two advocates are arbitrators in the main agreement. So that's also unworkable that way.
Sorry?
It's interestingly, the escrow holders are the named arbitrators in the main agreement. So there was no intention in the escrow agreement to have.
How did that happen then? Why
happened
did
is
you
this
appoint them as arbitrators?
I'll tell you why, my lords. Because
the arbitration agreement itself names them as arbitrators.
Lordship.
The original share purchase agreement.
No. The escrow holders. Escrow holders are independent.
Escrow holders are named as arbitrators.
Lordship pleases.
In the original agreement.
Lordship pleases. So therefore, there was no intention.
That issue of conflict is not before us.
So what I'm submitting is this. In the escrow agreement, there was no intention of an arbitration at all. The escrow clause, kindly just read clause 6 again, my lords. Page 8, my lords. Page 8. It is quoted in the impugned judgment. Page 8, para 14.
Yes, read it.
Clause 6, my lords. In the event of any dispute or difference arising in implementation of this agreement, which is escrow, my lords, the decision of escrow holder shall be final and binding on the parties. That is one part.
If I'm not wrong, this is not escrow account.
This is the escrow agreement, my lords. Paragraph 14, my lords.
9.10 is about share purchase agreement.
Right? No, Lordship is right. Kindly see paragraph 14 at page 8.
That is escrow.
So this is about the escrow only.
That is escrow.
Correct. But kindly see that.
Paragraph 12 is about share purchase agreement, which has an arbitration.
No doubt, my lords. Kindly see
but
the
now come to
part
14. Now come to 14.
My lords. In the event of any dispute or difference arising in implementation of this agreement, which is escrow.
Correct.
The decision of escrow holder shall be final and binding on the parties. Now kindly see over the page, the relevant portion. However, if any dispute is referred to any of the parties to arbitration in accordance with the arbitration clause contained in the said document recording share transfer, in that event, the escrow holder shall keep the escrow amount with them till the disposal of the arbitration proceedings and shall abide by the result or decision of the arbitration. So, Malas, the intention was this. Escrow holders are independent people. They retain this 30 lakhs. In case there is a dispute in the main share agreement between me and the purchaser, and an arbitration is started under that agreement, then this escrow account would just be left as it is and subject to that. Right. That is all.
Correct.
Now, Malas, there is no dispute between me and the purchaser. There is no arbitration at all ever initiated by them. 2000
dispute is between whom?
Me and the purchaser under the main agreement. No arbitration till date.
Then the dispute is with whom?
Me and the escrow holders for return of this 30 lakhs. Okay. Because we are saying this amount, there is no demand, nothing. The amount is still lying with you. Therefore, the decree what I'm asking in the suit is only against the escrow holders for return of 30 lakhs. That is all.
He holds it in trust.
Lordship, I'm so grateful.
For the parties.
I'm so grateful, my lords. Subject to, if at all an arbitration happens.
In fact, you don't have a contract with them.
Yes, my lords.
But escrow agreement, but who are the parties to the escrow
All the parties.
Escrow agreement, the escrow holders are parties. to the
Lordship,
agreement?
please, they are. Escrow holders are parties.
Escrow holders also signed the agreement?
Yes, my lords, they are parties. They sign.
Why did they sign?
Well, it's because they are the ones who had to keep the money.
And both the parties who were there in the share purchase agreement.
Both were parties, my lords.
Parties A and parties B who were there in the share purchase agreement, coupled with the escrow holder.
Lordship, please.
These three entities have signed the.
Lordship, please. Because the idea was, if the statutory liabilities accrue in the process, then from the escrow amount, the money will go. So that's why the escrow holders have to release. If nothing happens, they will return back to me. Now today, no amount has gone through. There was no claim in between.
Right.
I'm seeking. So that's why I filed a suit. There was no independent arbitration agreement between us in this particular agreement at all, my lords.
What you're saying is right.
But my lords,
But would arbitration not be better for you?
my lords, it would not be, my lords. I'll tell you why.
Why?
Because the main arbitration agreement was never done. Now 10 years have passed by.
What?
10 years have passed by since 2016, the last cause of action.
So both the parties in the share purchase agreements are aggrieved against the
No, my
escrow holders.
No, no, purchaser is not. There's another very interesting part, my lords. When I file a suit against the escrow holders, they don't move a section 8. The purchaser moves a section 8. And they had no look.
Because the escrow account agreement.
Lordship, please. My lords, may kindly see annexure P2 at page 70.
Item 13. Page 17.
70, my lords.
You are. Who are you? Priyank Gupta, is it? Devrat Gupta.
Page 70.
Devashish Gupta. Indoor Tea Company.
Indoor Tea, my lords, is
What's the name of the escrow holders?
Kindly see, my lords, page 72.
That is Hariram Gargi.
Anil Chaudhary and Sandeep Agarwal. Referred to as escrow holders.
Third party. Third.
My lords. Fourth party. Fourth party, my lords.
Huh?
Fourth party. And kindly see.
Fourth party.
Fourth. It's
That's
not
the escrow holder.
Yes, my lords. So now, my lords, the purpose was is page 73.
Where is the obligation of escrow holder?
No. Kindly see page 73, para 2, the obligation. Asian, may I read, my lords? Clause 3, clause 2. Simultaneously with execution of this agreement, Asian Group has made over a sum of rupees 30 lakhs, the details whereof are given in first schedule below, to meet unclaimed gratuity as per annexure A to this agreement to the extent of rupees 15
This doesn't
lakhs.
have an arbitration agreement.
This does not have.
Notice.
I'm praying for a stay, my lords.
Stay.
I'm so good. Ali.
Well, this is originally a dispute between lessor and lessee. I am a lessee. There's arbitration clause. I go to
Status
section.
quo.
You
got a status quo.
Well, yes, the status quo
Termination.
in section 9. In order to defeat the status quo, writ is filed asking mandamus for the fresh connection. The very purpose of the status quo is defeated by the
Electricity connection.
But on that day,
company or what is it?
Well, this is
What is it? What is the connection is to an industry? What
industry. So I was the industry owner. I was running the industry.
Measure.
I gave it on lease on the status quo.
Understand that your status quo can't be a ground for.
No, the status quo was the purpose was the plant was not running because electricity connection is my name.
The problem arose because
Yes.
of the reason that grant or non-grant of the electricity connection has got nothing to do with the lease part of it.
No, this was
important. Whether the lease is status quo exists or not, electricity connection is governed by the electricity.
No, the section 9 was primarily for this. I'll just show that.
To do with
Kindly see my section 9 because the obligation to pay was on that person, on the lessee.
You want us to disconnect the electricity?
No, today the question is that all these issues should be looked into by the arbitrator. Writ court can't get into it. And kindly see the statement which has been...
Writ. What are you saying? How is it a writ?
It's a fresh writ which has been filed. Just to make
the
it clear.
termination.
Yes.
The termination.
After termination. Today, if on that day the plant... But today, if somebody start constructing in my property and start...
We'll tell you why it is.
Yes.
You got a status quo.
Yes.
Because of that status quo that was treated as an excuse For the electricity department to disconnect.
No.
That is why he went in writ.
I'm sorry. I must correct. Electricity connection was disconnected much prior. On the day when status quo was passed, the date of disconnection is 2/12.
Correct us if I are wrong.
Yes, page 1.
We are wrong, just 1 minute.
Yes.
The status quo order on 24th December 25.
Yes.
Disconnection is 3rd of January 20.
No, 2/12/2025, their own pleading, page 130.
2/12?
2/12/2025.
What is that order?
Page 130, that's a disconnection which happened. Page 130
to
2/12/2025. And that's what the statement is.
You
Malas,
never
if we
mentioned
see,
about that at all.
I can see from their pleadings. Their pleadings is the writ petition, page 130.
Why was it disconnected?
Because they were not paying the charges. There are 2 odd crores of liability which has been created because I was the owner, the securities, everything was given to them. They were using the premises, electricity was not, dues were not paid, disconnected. So this was much prior. Page 130, para 10.
You can't deprive persons of
kindly see, assuming in an industrial lease,
anything like that.
in industrial lease, if my property,
Suppose tomorrow your stay is vacated, but what right? Well, what's your privity about it?
well,
Between electricity department and him.
no, I'm grateful. I must answer this question. If the original dispute was pertaining to electricity charges not being paid and the liability coming on me, they are asking for restoration of a same electricity connection today to say which was disconnected. Plant was not operational. I'm saying the termination means the property should come back to me. They can't enjoy the property and run behind the back when the status quo is given. Writ court can't defeat that position. Otherwise,
It's got nothing to do with running the industry.
No, it's the running the industry. Disconnection means the industry is not being run. Well, that's what they kindly see.
Running or no running is, they are conflicting 2 issues.
Well,
Today there is an electricity disconnection by virtue of 3rd January 26 order.
No. I think factually, Malas, I must.
Okay, whatever it is,
2/12/2025.
show the writ prayer.
Yes.
One by that. Just go the prayer.
First, we kindly see page
Writ
1.
prayer.
Yes, Malas. Writ prayer is at page 138, Malas.
What does it say? 130.
Page 1. Para 1.
Page
138. I'm sorry.
130.
138. 130 is the only for the limited purpose to date of disconnection.
13.
No.
13 or 130?
138. 138, Malas.
Okay, we got it. You got it. Just read.
Yes. Issue a writ in the mandamus directing respondent number 1 to restore electricity supply to the petitioner. Direct respondent number 1.
There's no such thing here. Wait, just see the body of it.
Yes.
Mention the date.
Page 130, para 10, just to clarify the factual position.
The petitioner company deals with the
perishable items holding stock worth 1 crore approximately. Respondent number 4 had left the petitioner without any electricity since 2/12/2025. This is the date of disconnection. Was moved the stocks out of the cold storage vicinity and a large stock is at the act. So factory was shut on that day, and that's
cold
what I
storage.
said.
It's a cold storage.
It's a cold storage.
How can you
today that's the one part. Cold storage is the one part. So what I'm doing is, this is the meat processing plant. The meat process, I was running the plant. I gave them on a lease. They refused to pay. And cold storage is a part of the plant. Today, the status quo means what? The whole purpose of Section 8 in the arbitration is defeated. If today the writ court start getting over and above Section 9 order, then the whole purpose will be defeated, Malas. Which practically means what? Look at this, Malas.
So then let us see the cause of action. What did he say? 212 is a little misleading. Where has he mentioned 3rd January 26?
3rd January 26, if my lords can kindly see my...
No, there is something more than what meets the eye. Why did he wait till January 26
page,
to go to the court? Oh, there's
page 1. Yes. Page 132.
The Balbir Singh.
11.
The date that you are saying is 2nd December 25.
Yes.
He went to the court on 4th January 26. So
yes.
Few days in a month's time, irrespective of a date prior to the status quo of 2/12/25.
I think I must factually clarify this. So far as the original factory or plant was, my electricity connection in the name of lessor owner was there. He was under the lease responsible to pay for operation of electricity charges, not paid, disconnected. When the disconnection was there, the status quo order is passed, which means that you don't run the plant and keep it as it is. That was the status quo in 9. He goes and files his new connection in his name. When he files in new name, they give on a day one, on second day, electricity department disconnected based on the status quo order. That's a statement in the impugn order. They do not restore.
3rd January.
Yes, kindly see the impugn order, only one statement by the Punjab state. Page 2, para 2, Malats. Miss Raina Sabarwal, I'm sorry, page 2. Page 2.
Is directed to.
I'm sorry, page 2, Malats. Yes, may I please? Miss Raina Sabarwal Thakur has put in appearance on behalf of respondent number 2 and 3, which is Punjab state, filed a memorandum.
Ex parte?
Yes, she submitted PACL was not a party.
It is a notice issue order, huh?
No, last line, on the bottom of the page. In the meanwhile, the supply to connection be allotted in the name of the petitioner, which means first illegal connection is disconnected. They go and say, give me an.
You are too terribly over anxious.
No, Maladi, today the question.
Your client is over anxious, huh?
No, Maladi, I must point out.
All that the Supreme High Court has done is, on his writ petition, they just issue notice.
Yes.
And they serve as standing counsel.
Yes.
Your advocate, I think Raina Sabarwal,
no, Mike, it's a state's.
So you are not even there.
No, Malati.
And respondent number 4 be served for 17/4/2026. In the meanwhile, it's an ad interim order.
Malati,
what is the so?
Yes. I must absolutely. I must point out.
Nothing doing.
If today I succeed in section.
This is an over anxious.
Well, look at the consequence. Kindly look at the.
Go and tell the court it's just issued notice and passed an ex parte interim order.
That position has been informed by the board, which is para 2. Court knows there is a status quo order. Kindly see in para. She submits that the PSPACL was not a party to the proceeding before the learned district judge and the electricity.
Response be filed before the next date. When is the next date?
7th April.
Maladi, next.
Dismiss.
Maladi, kindly see this.
Dismiss with cause.
Maladi, the issue is that it's a very, very serious jurisdictional issue, Maladi. Can today, with these facts, the High Court in a writ.
We'll just tell you simply, this is a over anxious landlord
Maladi,
who wants to.
Today, am I not supposed to get the protection which in section 9 given?
Don't do this overbearing. Dismissed.
This is the final relief, Malad. Someone can writ is the final relief.
Case is listed next week. Go ask them to vacate the interim order, ex parte interim order.
Malad,
nothing.
Malad, in the meantime, this should not come in my way.
Who said it will come in your
way? Malad, I'm saying something. If today when I go there and I disclose them and I find a section 8.
Imagination.
Malad, we have already facing this, Malad. Plant is in operation. In spite of a status quo, I succeeded 9.
Ex parte order, Balbir Singh. Do we need to tell you with your experience? Dismiss.
Very well.
Nothing more.
Malad, may I withdraw in that event? I don't want to be prejudiced on this aspect. Very well, Malad. I'll do that.
You know this.
Grateful.
Item 3.
Yes.
Because this deserves consideration. The reason is, as your lordships will have noted, it's a very detailed speaking award in my favor.
51-page order is written.
The award is for 5 crores and 18 lakhs.
89, sir, you see the
Section 34 in my favor.
Express.
And section.
I'll take notice, but the Honorable Court, High Court, as Malords had also the judgment pan developments, where the High Court says that the arbitrator, ought to have considered the fact that it has to be within the 4 corners of the terms of the conditions.
We'll examine it.
Yes.
We'll examine if he has exceeded that mandate of a contract. He can't go beyond it.
Yes. That's what the Honorable High Court has said. Well, 3 things the Honorable.
What was the need for them to write such a big judgment?
Well, it's because, of course, 34 had to be, otherwise
argued.
The other side would have said it's a very cryptic order.
Samiran, you are accepting notice. Samiran Sharma appears on behalf of the respondents. Heard so and so. Kalyana, senior counsels. Samiran Sharma accepts notice. I'll issue notice. Just tell us the contractual clauses.
Yes, there are 3.
And 3 contractual clauses and
okay, we'll find
whether he has exceeded. Just short note, that's all.
The very detailed arbitral award, oral evidence, cross-examination, some dozens of documents read
But
and a
still
finding
they can- they can-
recorded that there is negligence on their part because
They
of
can
the
still
whole.
go wrong. There's nothing surprising. They can still go wrong.
High Court says that the arbitrator makes out a case which was not even pleaded, not even claimed.
Find your response.
Please, oblige. Great.
No interim orders, no, Mr. Diwan?
They have withdrawn case.
So what can I ask interim? Because it's been set aside.
Yes.
Anyway.
Oblige.
You know, for the petitioner, the High Court takes a very curious stand, my lord. Radhakrishnan stands overruled. The High Court says, though it is overruled.
The disputed question of law, not.
My lord, what is the disputed question of fact, my lord? The voluminous.
What is this?
Various allegations of fraud.
Everything
You
is.
saw that other judgment which you.
Your lordship judgment, my lord, Bihar state.
Bihar state.
Everything is in my favor, my lord.
Bihar state is against you.
But it's a serious fraud.
It's a Bihar state is.
My lord,
Bihar
if my
state
friend
is a
permit-
CBI inquiry.
Lord, clause 5 and 6, conclusion 5 and 6, your lordships have said serious fraud
Court
altering
judgment.
Razia Begum, my lord judgment, my lord.
High Court judgment.
And the finding here is by the appellate court is,
That's
the
the-
finding is, my lord.
It is not a. Tell us what. Okay, now that you've intervened. Is there a criminality in it?
That's what I wanted.
In the sense that is there a criminal case pending?
The case, no, there's no case, criminal case filed by him. But the allegations made by him and the finding is siphoning, breach of trust.
These are exactly what the arbitrators are supposed to do with substitution of a court by an arbitrator. Take evidence. Don't the arbitrators take examination of the witnesses?
Of course, my lord, but your lordships
Then
have said, my lord.
disputed questions of fact are to be decided by arbitrator.
Your lordship.
And his high courts are seem to be assuming that they are writ courts or what?
In fact, here this is concurrent, all three, my lord. Arbitrator rejected.
Concurrently wrong.
Court rejected. High Court rejected, my lord. All.
But what else does the arbitration is supposed to do? Finding a fact.
And simplicity of finding of fact, maybe, my lord, but here is a.
Unless.
Yes.
You see the extent to which we have gone in that Bihar.
Yes.
There were CBI cases.
Please, but
There were CBI cases pending, but we still thought that there are issues where arbitration could go on, so we permitted it. But this is a case where at the the simple.
What I say is, my lord, what I say is, I will just clarify, my lord. What I say is, there are 145 agreements of sale, 145 sale deeds. Sale consideration shown in the agreement of sale doesn't reflect in the sale deed. They have misappropriated that money. They opened another bank account. They have received the money there. Lord, let me put this, because my friend has not even filed the partnership deed. Yes, yes. Copies. Yeah. Thank you. Para 21, my lord. Subheading Roman 5, para 21. I'm sorry, my lord. Conclusion Roman 5, my lord, and 6.
Propositions, just see that. After we have formulated the principles,
Yes,
right?
it was 5, 6, 7 conclusions. Conclusion 5 and 6, your lordships have drawn a distinction between serious fraud and fraud simpliciter. His own SLP, my lord, pleads serious fraud, my lord. No, sure.
Important policy consideration.
We have highlighted it with these two tests.
And additionally, my lords, he has made non-parties to the arbitration agreement parties.
Disputes on serious fraud may not be. See, these are open textual words. The moments where serious fraud and fraud. I mean, how are you to case, you will have to decide. Because we were sitting in two combination.
Please.
We couldn't do anything more than that. Fraud may not be submitted to an arbitration. So it's a very serious allegations of the fraud. I just quoted Nariman's order.
Yes,
serious allegation fraud is to. Then we have answered this. See, look at this. Serious allegation of fraud is to be understood in the context of facts. In the number 6. In Rashid Raza, This court laid down two tests. The first test is satisfied. Read that.
Yes, Lord. The first test is satisfied only when it can be said that the arbitration clause or agreement itself cannot be said to exist in a clear case in which the court finds that the party against whom breach is alleged cannot be said to have entered into the agreement relating to arbitration at all. The second test can be said to have been met in cases which allegations are made against the state or its instrumentalities of arbitrary, fraudulent, or malafide conduct, thus necessitating the hearing of the case by a writ court in which questions are raised, which are not predominantly questions arising from the contract itself or breach thereof, but questions arising in the public law domain.
In the public law domain, that's the point.
7, my lord.
So therefore, they
Disputes
transcend
involving-
contractual relationship.
Kindly see
Then
this.
become a public law issue.
7, my lord. Disputes involving allegations of serious fraud need more clarity so that there is certainty about the availability of
I
the
added.
remedy. At least once in one instance of serious fraud will be there where disputes involving allegations having criminal law implications.
Correct.
Transcend inter se disputes between the
the test.
contracting parties and attain public implications.
Public implication.
Where the ramifications could directly or indirectly
Directly or
affect all
indirectly.
parties and impact integrity in governance, accountability, public service distribution.
That is what I-
Here, my lords, he has made 5 and 6 parties.
That is what- Otherwise, arbitration is there. What is the?
In fact, he has made 5 and 6
Covered
parties
against
who
you.
are not party. My lord. Let me put the reply because he has not filed the partnership deed. He has not filed the documents to show, my lord, that 5 and 6 are not even parties to the arbitration.
Issue notice, issue notice. Who is appearing for?
For 1 to 3, I'm appearing for 1 today, but he'll except for 1 to 3, my lord. Others, my lord, notice will have to go.
Not issue notice, so and so accept notice on behalf of the respondents.
Grateful.
Citation. ये फाइल में रख देना उसे.
That's okay. And this is followed by a lordship in Rajda Begum.
Yes. I will look at that judgment.
My lord's judgment, my lord in Rajda Begum. This para 21, your lordships have quoted with approval.
Correct, correct.
My lords, I appear.
Arguing counsel is appearing through VC, Your Lordship.
My lords, I appear in item number 17 with Mr. Deshpande.
Just
Just one clarification, my lords, for my apology that annexure P5, there are certain mistakes while doing the translation. So that
the provision.
Corrected copy is available at the bench. If my
No, the
lordship,
provision, sir, we will see if you have the power or not. Which is
my lordship, there is no inherent powers under the under section 101. But when there is accidental slip, the judicial judgments are there which says that if there is accidental slip or omission, it can be corrected even by the quasi-judicial authority. What the Honorable High Court has held that it is not the clerical mistake which he has curated, but he has adjudicated or determined the rate of interest by way of corrigendum. That is what at para number 9 the observation has been made. And I can...
We'll issue notice.
My lordship, may I request stay? Because properties are attached and the Honorable High Court has granted stay for 4 weeks of its own order.
See, which means that you will recover the interest also.
My lord, because ultimately it's a loan amount and
True. True. You can't get an ex parte order. Let the other side come. Take out dusty notice if necessary.
My lord. I'm not going to. May I say only one thing? I will not recover the amount, but let there be that the respondent should not create any third party interest. Ultimately, if the property gone, then we will be in the post.
The correction is only adding or deleting of interest part of it. Main sale certificate is there. Where are you? You are somewhere else. It's only the interest part of it. That's all.
Correct, but they have paid the loan amount, principal amount, and
only an interest you will get or not. That's the only question.
Correct, my lord. My lordship may give me a returnable debt in that case.
Yes. Right.
Much of
You issue notice.
petition. Dusty and.
May please, Your Lordship. Yes, madam, why you should go to the High Court? What, like, against an order of adjournment, right? You file a writ appeal. The division bench grants you relief. Despite that, you come to the Supreme Court on the basis of subsequent events. I mean, if subsequent cause of action is accrued to you after the order passed by the division bench, what is the forum? Where should you go?
Your Lordship, I bow down to that we should have gone to the High Court. But Your Lordship, the problem is that the High Court order is cryptic, Your Lordship.
What?
Your Lordship, because there was...
High Court should have dismissed your writ appeal, madam. It was not maintainable against an order of adjournment. but still it has shown indulgence. The division bench has permitted you to appear in the examination, and you have appeared.
Your Lordship,
Now, if there is any subsequent cause of action, you should you not approach the High Court, or
Your Lord-
should you climb the ladder and come to Supreme Court? What is
Your Lordship, I bow down to that. Your Lordship, can I
Go
just
there,
take
go
2 seconds, Your Lordship, to just explain one thing? Your Lordship, this is a case of a person, Your Lordship, because of the technicalities of the university, Your Lordship. Your Lordship, there is a specific rule passed by Delhi High Court, Your Lordship, that the
0.23%.
Yes, Your Lordship. Okay.
Issue notice, issue notice.
Grateful, Your Lordship.
Close this. Serve Dasti in addition. For one class, only one attendance, 1 day attendance.
1 day, Your Lordship, and that too the technicalities of the university, which is an admitted fact.
Unpardonable. Poor fellow lost so many precious years.
Yes, Your Lordship.
Notice serve on Dasti.
And Your Lordship, BCI mandatory requirement is 70.
His seventh class is 7th semester is over.
Yes, Your Lordship.
7th semester exams are also over.
No, Your Lordship, it will happen in May, the supplementary.
Now 8th semester, what's happening?
8th semester main exams will start in May, Your Lordship. So in the interim,
Exams are over 7th semester.
yes, Your Lordship. All this while we were pursuing remedy in the High Court, Your Lordship.
What will do?
So have you appeared in 7th semester?
No, Your Lordship, I kept persisting. They did not let me sit in the
Can you go to the
examination.
Can you take the 8th semester exams?
Your Lordship, I have judgments to that effect.
Can you
Yes, Your Lordship, the promotion policy allows me to do it.
can you sit in the 8th semester classes?
Your Lordship, only the law says that in exceptional circumstances, extra classes can be handled by the university, Your Lordship.
You could be promoted, right?
Yes, Your Lordship.
So you actually took the 5th and 6th semester?
Yes, Your Lordship.
You appeared in 5th and 6th semester as per the division bench's order.
Yes, Your Lordship.
And so far as the 7th, you didn't.
They didn't allow me, Your Lordship. And Your Lordship, it is interesting, before the Allahabad High Court, all this while they said we have allowed everyone whose attendance was 73%. Now we could relax it, but now we can't relax it because 7th semester is also over.
Copy of the special petition shall be issue notice. Copy of the special petition shall be served on the standing council for the state of UP. Which is the college, university or college? What is
Christ University, Your Lordship. Christ deemed university.
Dasti on? We permit Dasti service on the Christ University. Pending disposal of the special petition, the petitioner shall be permitted to attend the 8th semester classes.
Extremely grateful, Your Lordship.
List after 2 weeks. Take a date and come back. Serve on them.
Extremely grateful.
Item 19.
There's a letter.
Yes.
Please, Your Lordship. I've moved a letter for adjournment, Your Lordship.
All right.
Item 20.
In 20, my lord, the difficult submission first, my lord.
763.
Page 124, if Your Lordship. No, my lord. That's easier. 124 is more difficult to make if Your Lordships can, my lord. We are in Your Lordship's hands, of course.
What is 124?
124, my lord. Lordship may see 124.
Page?
124, yeah. Annexure P10.
Oh, restoration issue.
No, my lord. Annexure P10 is the learned single judge's page 124.
So that tenure of the Legislative Assembly is over, no, Mr.
No, Lordships are right. Before I proceed, my lords, I just wanted to bring this to your Lordship's notice. Please have page 124. At the top, lord. This is the learned single judge's decision, lord, as his Lordship then was.
Oh.
I just wanted to bring this to your lordship's notice. No, it's in your lordship's hand. We can.
No. You must tell.
Yeah,
You must
therefore,
tell us.
lordship
It's
told
the
us on an earlier
responsibility of
occasion
the
also. It's our
council.
duty too.
See, we have 80 matters every day.
No, therefore I said.
Even remember, it's the duty of the council to tell us if the judge had already appeared, has delivered an order, or somebody like me had appeared in the matter. It's your duty.
No, therefore, Lord, we wanted to
Thank you
fulfill that duty, and lordship may appropriate order, Lord.
Okay, you survived for the present.
Lordships have seen through it, but nonetheless, it was our duty.
Fine. Nice. Not before a bench.
Deeply obliged.
This comes for final hearing. I have, my lords, a list of dates and.
Oh, this is the 7-11.
Yes. So I've got a list of dates. It will be important. I've got my lord, written submissions along with the judgments. My lords, because first only the bear in mind is which I had corrected. May I hand over the list of dates? Give the others. Let's give it. So, well, it's just 2 pages, so I'll run through it, but there are some documents which are important here.
The 7-11 issue.
Yes, my lord, it is important.
Very intelligent.
My lord, it's not even the full page. Please see the second page. I've cut out a few. But no, my lord, it, to the extent that there is a certain flow, because I'm saying
A4 multiplied by 2.
My lord, I am saying this because it's
A lighter vein, don't take everything seriously. Just
we
smile a
have
while.
no choice but to. It's a question of, my lord, somebody being non-suited. So, my lords, please see 27/8/2002.
All right.
A sale deed was executed between so-and-so and the petitioner's predecessor for the sale of a piece of land at measuring so-and-so. My lord, this is the subject land. Consideration amount was 3 crores. Note, out of the subject land, Tamil Nadu Highways Department acquired 34 cents for road widening. Then, my lords, 28/8/2006, petitioner obtained a building permit from the Chennai Metropolitan Development Authority to build Digital Zone 1, comprising basement, ground floor, plus 7 floors with a total built-up area of, my lords, 25,550 square feet. 14/3/2011, in order to build the subject property, the petitioner obtained a loan of 79.19 crores in 2 tranches, 72 crores on so-and-so and 7.19 crores on so-and-so from Standard Chartered Bank. Accordingly, petitioners executed a memorandum of deposit of title deeds in favor of the bank, thereby creating a mortgage. Well, this is going to be a little important because there was a certain amount which I owed to the bank as the owner. I was the owner of the property.
You did it?
Yes. 11/1/2018, Standard Chartered Bank issued a notice under Section 13(2) Sarfezi Act seeking a recovery of 72.63 crores. Also issued a notice under 13(4) for taking over possession of the property. Eventually, it filed OA number so-and-so. 16/6/22, the petitioner and Standard Chartered Bank entered into a one-time settlement whereby petitioner was required to pay a sum of rupees 55 crores. Parties filed a joint compromise memo before the DRT Chennai. Petitioner paid 27 crores. However, balance amount of 28 crores remained due and payable. Bank extended the payment date to 19/10/2022 on 14/10/22. Then, my lords, 22/11/22, the subject property was valued at rupees 161.66 crores by one Sahitya Associates at the instance of the petitioner. The guideline value or circle rate was 63.16 crores. My lord, this 161 crores it was valued at will give your lordship some idea of what the market value of the property was. Of course, for 7/11, technically this is not necessary, but it will show the kind of fraud that has been played on me. Please see now, January 23, petitioner and bank entered into a fresh settlement whereby the petitioner was required to pay rupees 32.5 crores instead of rupees 28 crores. At the same time, petitioner entered into a negotiations with the respondent. Now, my lord, pausing here for just a moment. This 32 crores, my lords, because I was under pressure to pay to the bank, I was in need of very quick liquidity to be able to pay off the bank. And that's why I agreed to this, my lord, 2-tranche agreement, which will, my lords, come through. Number 8, 17 to 23, P1 and R1 came to an understanding that the respondents were required to pay 111.6 crores to P1. This is for the, my lord, the property. The entire deal consisted of 2 parts. A, sale of property, that is, my lords, the flats, and B, refurbishment and leasing. They had an arrangement to record said understanding in writing by way of a memorandum of agreement. The counsel of the respondents commenced the drafting of the MOA. The WhatsApp chats show that the execution of the MOA was a mere formality. My lords, again, please note here, I am going to have to refer just to satisfy your lordships that mine was a very honest case which I have pleaded in the plaint, and that is all my lords have to look at in Order 7, Rule 11. Now, my lords, in these WhatsApp chats, because there is no formal agreement.
We'll see your plaint after you complete this.
Very well. My lord, what I'm just, please note this, the WhatsApp chats show that the total consideration agreed to was 105 crores. 17/3/23, petitioner executed MOA, which was drafted by the counsel of the respondents on the basis of the understanding between the parties. This is my pleading in the plaint. Under the MOA, the subject property would be sold vide 8 separate sale deeds for a consideration of 58.6 crores, which includes rupees 6.6 crores towards stamp duty. Out of the said amount, rupees 32.5 crores would be directly paid to Standard Chartered Bank. This is the pressure on me because I needed that immediate liquidity. The petitioner is required to release the attachment of the property made pursuant to the order dated so and so. That was some other part. Now please see further, next page. The petitioner was required to carry out refurbishment and look for long-term tenants. In lieu of the same, the respondent was required to pay a sum of rupees 53 crores to the petitioner. Out of the said amount, respondent was entitled to retain the amount of rupees 33.6 crores for obligations to Edelweiss Assets Reconstruction Company. Then, my lords, 3/4/23, Standard Chartered Bank's consent letter to accept 32.5 crores. That's how I was able to settle that. 3/4/23 again, the petitioner and respondents entered into and executed 8 separate sale deeds for the subject property. Sale deeds were registered on 19/4/2023. Note, the petitioner was pressured into entering into the sale deeds given its obligations to Standard Chartered Bank. Respondents, on the other hand, claimed that execution of sale deeds was required in order to seek disbursal of funds from Hinduja Leyland Finance. 3/4/23, Tamil Nadu, my lord, this is not so relevant. 3/4/2023, Standard Chartered Bank handed over title deeds to the respondents after it paid rupees 32.5 crores to it. 21/4/2023, order of District Revenue Officer Collectorate, Chennai, directing payment of stamp duty of so and so. Now, my lords, please see. In the meantime, my lords, at item 15, I have said possession was with me. I was paying electricity bills, etc., etc. It is in the, my lords, during the proceedings before your lordships that they had taken time on one occasion on the ground of some medical emergency. And then, my lords, goons were sent to the property. We've annexed photographs and your lordships. So at that stage, please to grant a status quo order. Plaint, my lords, is filed here on June 24. I'll read the relevant portions to my lords. Then, my lords, in September 2024, an Order 7, Rule 11 application is filed on the ground that the plaint does not disclose the proper course of action and the relief claimed was undervalued. Plaint is insufficiently stamped. My lord, before the trial court, my lord, I succeed. Order 7, Rule 11 application is dismissed. And, my lords, thereafter, it is, my lord, set aside. That order was set aside by the High Court by going into the merits of the case and conducting what we would describe as a mini trial. That I'll come to, my lord. My lord, may I please first read the relevant portions of the plaint, which your lordships will find at volume 2, page 4.
In the main paper book, plaint is not there.
My lord, second volume.
Plaint is not there in the main paper book. Page 402.
My lord, page 402, it's in the second volume.
Wherever it is. Hey, 402.
My lords have it? Yes. So, my lord, I'm not troubling your lordships with... Give me my scribbled on the back.
Give the paper.
So PDF expense is coming up. No. No.
Malo. Yes, Malod, I'm not going to trouble your lordships with para 4, 5, 6, 7, etc. because I've briefly already indicated from my list of dates that is what I have needed. But if your lordship starts now from para 8, because this is where I explain the two-part, Malod, the structure of the deal. Para 8, Malod, at 406. The first defendant is a husband of Mrs. Aarti Lalwani, who is a company director of the second to 10th defendants. First defendant agreed to purchase the plaintiff's land together with Software Technology Park building measuring Malod's 255.05 square feet of built-up area consisting of basement, ground floor plus 7 floors, which is known as Digital Zone 1 situated at so-and-so, Karapakkam, Chennai. The plaintiff agreed to sell the suit property to first defendant for a total consideration of, please note, my lords, 111 crores 60 lakhs, including tentative value of stamp duty registration to the cost of defendant and basic consideration as rupees 105 crores. The first defendant, representing other defendants, has agreed to purchase the same price of 105 crores, which includes settlement of one-time settlement offer from Standard Chartered Bank based on the property valuation report dated so-and-so for 161.66 crores. The total sale consideration was finalized by the first defendant and plaintiff company, Mr. So-and-so, in the following manner. Now, your lordships will see how it is a two-part deal and they have walked out after my lords executing the first part. 1. The plaintiff company have offered to sell, convey rights and interest over the suit property to the first defendant as one part of structured transaction MOA for sale consideration of rupees 58 crores 60 lakhs, which includes the stamp duty and registration fees payable on the sale deed, rupees 6.6 crores 60 lakhs, which is to the account of the defendants, and net consideration payable to the plaintiff as rupees 52 crores, for which sale deeds will be executed as per the rear side guideline value of the property. Now, my lord, this part was done. The first defendant ought to pay the outstanding amount directly to the Standard Chartered Bank and receive the title deed of the suit property, which was also mentioned in the SCB settlement letter. Enclose the no due certificate obtained from Standard Chartered Bank upon settling the OTS dues on 3rd April 23. The sale deed execution by the plaintiff to and in favor of first defendant or his nominees, which are 8 special purpose vehicle companies formed by first defendant in respect of each floor, 8 floors, each floor 1 SPV in the building. The plaintiff has undertaken to lift the attachment in so-and-so filed by Tamil Nadu. My lord, this I can skip. Then 5, the first defendant has agreed to pay rupees 53 crores. My lord, this is now in addition to the earlier sum. 53 crores to the plaintiff for carrying out, including such refurbishment work required for leasing the entire building, ground plus 7 floors, to fetch a minimum rental of rupees 40 per square meter, subject to deduction withheld of amount payable to the plaintiff to Edelweiss Asset Construction Company, Indian Bank, as per ROC chart. Then, my lords, the plaintiff has agreed to arrange leasing the entire building within a period of 6 months from the date of execution of MOA on or before 30/9/29. And in the event of any portion of building is not leased out, the plaintiff shall be liable to pay compensate the defendants herein equal to the monthly rent as base rent of rupees 40 for the unleased portion. This is under normal pretext that defendants will release the sale deed from SRO Nilankari immediately upon registration as for leasing. Foremost due diligence document required by any prospective tenant will be the verification of original title documents. In case, now my lord, this is also important, in case of failure of defendants to honor the remittance of rupees 105 crores, plaintiff is obligated to only return the actual remittance received by plaintiff without any interest on the date of reconveyance of the property by defendants to plaintiff. In case of failure of plaintiff to lease the building for his non-performance only, then plaintiff is obligated to refund the entire actual remittance received from defendants along with 24% interest till the date of reconveyance of the property. In both the circumstances, the property has to be only reconveyed to plaintiff. In other words, my lords, there's a two-part structure in the deal. One is for the sale of the flats per se, and the second is for leasing and for refurbishment, which was I was required to do, for which they were required to cooperate. And the total consideration was 105 crores, excluding, my lord, the stamp duty. That was the deal between the parties. I'll show the draft MOA, which their lawyer prepared, and the chats between the parties, which show that total consideration agreed to was 105 crores. That is my pleaded case in the plaint. Now please see para 9, my lord. The plaintiff submits that accordingly, the plaintiff and first defendants have agreed to reduce in writing an MOA by incorporating the above said condition mutually agreed between them. My lords have para 9. The first defendant external lawyers, namely Mr. Santosh of Tatva Legal Chennai and Mrs. Jyoti, internal counsel of the defendants. This is, my lord, the other side had drafted the MOA with the terms above stated. So this has to be seen, my lords, on the face of it. This is what I have pleaded in the plaint. One cannot look at the written statement. The MOA drafting has commenced from 17/2/2023 and concluded on 14/3/2023. Between these periods, the information was exchanged between the first defendant and its representatives and his lawyer and plaintiffs by way of WhatsApp group. The WhatsApp message since 17/2/2023 till 15/3/2023 are filed herewith, and they may be read as part hereof. So, my lords, those chats, which I will show how the draft agreements were exchanged between the parties, and, my lords, 105 crores consideration. Well, just a couple of paragraphs of the plaint. Para 10. The plaintiff submits that the said MOA has been approved and accepted by the first defendants. A non-judicial stamp paper for the value of rupees 100 was purchased by the first defendant, bearing so-and-so in the name of the second defendant. So all this they have done. The MOA dated 17/3/23 was reduced in writing in the stamp paper and printed by first defendant and its representative only. The original MOA was delivered to the plaintiff for their signing. Thereafter, the original MOA was delivered to the first defendant office for signing by second director so-and-so. Therefore, as per the MOA dated 17/3/2023, it was agreed between the plaintiff and the first defendant that the plaintiff ought to have sell the suit property for total consideration of 52 crores, including tentative registration and stamp duty for approximately 58.6 crores, and the first defendant ought to have paid rupees 53 crores to the plaintiff for carrying out, including such refurbishment work as required for leasing the entire building to fetch a minimum rental of rupees 40 per square foot per month. Photocopy of the signed MOA. Milord, we signed it when they had prepared it. We signed it when we sent it to them for signing. Milord, they said we are not going to sign. Para 11, the plaintiff submits that the first defendant retained both the original MOA dated 17th March 2023 and did not hand over one set of signed original to plaintiff. Instead, he was interested and keen in getting only the execution and registration of 8 sale deeds, claiming that there was huge pressure from his bank for transfer or release of loan fund from his bank, Hinduja Leyland Finance Limited, and thereafter pressuring to only get the MODT registered. The first defendant provided the names and details of his nominees, 3rd to 10th defendant, to execute the sale deed by plaintiff. Defendant's company 2 to 10 incorporation certificate online copies are filed herewith, may be read so and so. And My lords, we have also stated at the bottom of 409, the first defendant has agreed to deliver the signed MOA dated 17/3/2023 at the time of the execution of the sale deed. The plaintiff company had requested first defendant to sign the MOA dated 17/3/23 by the director of the second defendant representing other defendants, but the first defendant postponed the same by assigning reason one after one. The first defendant said registration of the sale deed is important and then the registration of MODT is important. Then he has some health issues, family issues, under mental stress, medication. The plaintiff and first defendant have exchanged communication in respect of signed MOA in WhatsApp message. The available WhatsApp messages, which is a group chat including first defendant and representatives since 15/3/23 till 27/3/23 are filed herewith. Same may be considered part here. Now, therefore, my lords, after that, we have explained that they've reneged. After that, we should show what is the MOA, where it is. And the WhatsApp chats. And they have not been that. They can't remember that. So, my lords,
I think you can conclude with these two paras, nothing more.
No, so because there was one point which was raised by Mr. Sundaram, so I would like to just deal with that. So, my lords, at para 12, the list of the various sale deeds have been mentioned.
No problem. Then come to
para 13, your lordships have seen that it is structured transaction, 105 crores, etc. He's executed the 8 sale deeds, but he doesn't deliver the signed MOA, and nor did he allow me to complete the refurbishment work. Now, on the refurbishment work, he says, oh, you never even carried it out. That was the submission made across the bar, never pleaded, my lords, as far as we know, in the order 7 or argued before the trial court or the high court. But I'll deal with it anyway, because ultimately order 7, rule 11 is between the court and us as plaintiffs. Para 15, it says the plaintiff was not in a position to carry out refurbishment work required for leasing the entire building to fetch a minimum rent of rupees 40 per square feet per month. In fact, plaintiff got letter of intent signed from Reliance Smart to take retail space in the building with a rental of rupees 62 per so and so, but was unable to conclude due to failure in due diligence process for want of physical verification of the title documents by the tenants, which defendants were unable to provide. The first defendant and its nominees has categorically admitted and acted upon based on the MOA terms, which was finalized by their own lawyers and subsequently brought in the same in the MOA. It was signed by the plaintiff and delivered to first defendant and its representative for signing by second defendant. Your lordships have seen that. So basically, they made it impossible for me to carry out complete the refurbishment work.
Come to the improved order.
No, my lord, the prayer I have to show because they are going to rely on this.
Okay, prayer.
My lord, para 28, 414A. For a my lords, I would say that this is a clumsily drafted prayer. I would say that, but it still doesn't knock me out on order 7, rule 11. A, for a mandatory injunction directing the defendants to execute MOA dated 17/3/23 in favor of the plaintiff to enforce the same for recover the balance sum of 53 crores in respect of the sale of the unit property. Failing to do so, this honorable court may be pleased to execute a reconveyance of the property by 3 to 10 defendants in favor of the plaintiffs in respect of the suit properties. So, my lords, what we are saying here is, I'm sorry. So yes, my lords, as far as the MO that you execute the MOA, your lordships are fully aware of the proposition which we've got enough case law for, that where the terms and conditions between parties are agreed to either orally or in writing, the vital terms are agreed to, all it needs to be done is to be reduced into a formal document. That does not mean that there is no agreement between the parties. So what I'm seeking them, that they should execute the MOA, sign it, which has been prepared, I pleaded in my plaint, prepared by them, and I will show that you execute that and you pay me the balance of 53 crores which you are required to pay under this composite deal of 105 crores plus the stamp duty.
So basically it's a recovery suit then.
My lords, the first prayer is to execute the MOA. What, my lords,
What
ultimately
will come out of that recovery only?
No, first, yes, so they will, and I will perform the balance. They make it possible for me to perform the balance. I pleaded readiness and willingness also. My lords, in para 14, I have pleaded readiness and willingness.
In the ultimate analysis, what is it all about?
My lords, ultimately,
Ultimate analysis.
so my lords, perhaps a mandatory injunction for that.
No. In the ultimate analysis, it's a prayer for grant of the further consideration contemplated earlier.
Inter alia.
No, what else is there?
My lords, first and foremost, for execution of an...
You have not set up a case saying the whole sale deed is fraud. We never wanted to sell the property.
No, I'm not saying that. That's not my case.
So therefore, that's what we are putting
No,
the explain.
my case is, my lord, very simply, it's a two-part deal. It's structured that way. You have one, because you knew that I was pressured to pay the bank, you quickly paid that sum, executed the sale deeds, and then reneged on the second part of the transaction.
So therefore, first part is not an issue. The second part, reneged means what was he supposed to do in the second part? To pay you.
He was to pay me, and I was to carry out, my lord, get lessees, refurbish, etc., as provided, my lord, what we've said in the plain. The draft MOU.
Okay, we have seen the plain.
My lord, just a moment, my lord, draft MOU is on record, and I want to mention, because your lordships should not imagine that, should not think that this is a figment of our imagination, that it was 105 crores.
Whether you say it or you don't say it, the way to understand a 711 is to just read the plaint.
Yes.
We read the plaint.
Yes.
We read the prayer.
Yes.
We will see how the High Court has allowed it.
Yes. My lords, your lordships may see the trial court at page 439.
Not necessary. Trial court.
My lord, they've decided in our favor. All right.
You know that.
So, my lords, the impugned order.
It's the allowance of 711 which is more serious in nature.
So my
that
lord,
we'll see
in fact, their submissions also, if I may quickly read that, or your lordships would only like this.
We'll see the logic of the High Court.
So I'll go straight to my lord's para 23.
Whichever para you want.
Para 23 at page 14. 19? All right. My learned friend would like 19, so I'll read that. Page 13. The case on which respondent plaintiff has approached the court has already been set out here and above. It is not in dispute that even according to plaintiff's MOA was only signed by the plaintiff and not by the defendants. Yes, but that's why I was asking you to sign it. It is in this context that the plaintiff has sought for the relief of permanent injunction in the suit. The said relief is as follows. Your lordships have already seen that. Para 20. On even a casual reading of the said relief, it is seen that the relief sought for not only to execute the MOA dated 17/3/2023, but also to enforce the same by recovering the balance of rupees 53 crores from defendants 3 to 10 in default, seeking the relief of reconveyance of the property in favor of the plaintiff. My lord, in default, that is in the alternative. The other two reliefs which are sought for are as follows: for a permanent injunction restraining defendants, MN agents, so-and-so, from claiming under them, from alienating or encumbering suit properties in favor of third parties; for a permanent injunction restraining defendants, their men agents, or any other persons from interfering the peaceful possession, enjoyment of the suit property by the plaintiff. It is therefore the contention of the plaintiff that the plaintiff continues to be in possession and the defendants are sought to be restrained from interfering the plaintiff's possession, besides also encumbering or dealing with the property. Pursuant to the negotiation between the parties, which according to the plaintiff culminated in MOA dated 17/3/23, the plaintiff has chosen to execute 8 sale deeds in favor of the defendant's companies. In all the sale deeds, I find that there is no vendor's lien reserved in respect of any unpaid sale consideration. Lord, why should the court in 711 go into this? The sale deeds also covenant that the purchasers have been put in physical possession of the property conveyed. Admittedly, after purchase, defendants have also mutated revenue records, including patta in their names, evidencing lawful possession being with the defendant. This is not correct, but the court shouldn't have gone into this issue at all. 23. On a reading of the plaintiff does not deny the execution of sale deeds in favor of the defendant. It is the only contention that there was an earlier arrangement by way of an MOA in and by which certain amounts were agreed to be paid by the defendants. However, the said amounts have not been settled in full and therefore the suit has been instituted. Admittedly, the said MOA, even according to the plaintiff, has been signed or executed only by the plaintiff and none of the defendants have signed the MOA. Further, by voluntarily executing the sale deeds in favor of the defendants, admitting receipt of sale consideration and also handing over possession, the MOA, if true, or even assuming it was a concluded contract, it got superseded the moment the sale deeds came to be executed, conveying the property in favor of the defendant. So, my lord, there's a finding of novation. My lord, this is nobody's case. They said it's not a concluded contract. Yes, that's a matter of trial, whether it is a concluded contract or not. I annexed all the WhatsApp chats and the correspondence between us. Why should the court in 711, my lords, talk about supersession of my MOA? It is not open to the plaintiff to harp on the terms of the said MOA and contend that amounts are still due and payable to the plaintiff. It is not as if the plaintiff is an illiterate person or ignorant of laws. The plaintiff is a company incorporated under the Indian Companies Act, plaintiff having not chosen to reserve any right in respect of any unpaid money and not having chosen to challenge the sale deeds till date. It is not open to the plaintiffs to maintain a suit based on an incomplete and not concluded contract, namely MOA, and seek relief based on the same. So, my lords, a value judgment on my agreement, which I have pleaded, going on the basis of a defense set up by the defendants. In fact, the plaintiffs has also not valued the relief for the amounts that are sought to be recovered, namely 53 crores. As already seen, prayer is not merely for a direction to the defendants to execute the MOA, also for enforcement of the MOA by payment of 53 crores, failing which the plaintiff seeks reconveyance of the property itself. Plaintiff has therefore cleverly drafted the plaint by creating an illusory and disguised cause of action and avoided payment of proper court fees as well. My lords, I just... Lord, if I am to assume against myself for a moment, and I'll point out that case law, that if it is undervalued or court fees paid are less, a party always gets an opportunity to cure the defect. It cannot be knocked out straight away under Order 7 ruling.
Complete.
Yes. Last sentence on page 15. The plaintiff has chosen to couch the relief of mandatory injunction in such a way that it is nothing but a disguised attempt to seek recovery of a sum of rupees 53 crores. Even otherwise, plaintiff cannot maintain the suit based on a contract that is admittedly not concluded. Again, my lord, same. In this regard, the learned counsel for respondent has placed reliance on the WhatsApp messages between the parties to establish the case of the plaintiff that the defendants are conscious of the fact that they have not paid substantial portion of the total agreed sale consideration of rupees 105 crores. Even in terms of the MOA, as rightly contended by learned senior counsel for the petitioners, the consideration that is set out in the MOA is only a sum of My lord, this is not correct. I'm sorry. MOA is full, my lord, the entire amount. This is for the flat purchase. 58.60 crores, 60 lakhs.
24 also it's about the valuation.
Yes, it is only a sum. There is absolutely no admissible or satisfactory document produced on the side of the plaintiff along with the plaint to even establish as to how the total sale consideration of rupees 105 crores basic and inclusive of stamp duty registration charges of rupees 111.60 crores. Now, my lord, this lakhs, sorry. My lord, how can this be at all gone into and totally contrary to my annexures in the plaint? Just, my lords, for a moment, see, sorry, I'm troubling your lordships, but please turn to page, it starts at page 60. My lords, if your lordships come straight away, my lord, 63 it starts, and then if your lordships just glance for a moment.
Yes.
Say that they've, my lord, not even looked at the annexures to my plaint or the pleadings in my plaint. Page 68, this is the conversation which I have annexed to the plaint, where I say that the other side says to me, now you want entire 105 crores at one stretch.
All right.
So he knows there is this figure of 105 crores and that I want it in one stretch. He says he wants to pay it in a...
Rest of it is case law.
Yes. So now, my lords, my lord, please see further at 26, para 26. On a perusal of the said MOA, I find it is not even witnessed, and though it contains various schedules and Schedule B is supposed to set out refurbishment works, MOA has been relied on by plaintiff indicates that the said refurbishment works is only stated to be appended. However, there is no appendix to the MOA listing out refurbishment works. Therefore, MOA is a unilateral, incomplete document which cannot be enforced in a court of law. It is not open to the respondents to contend that he only seeks to execute the MOA at the end of the defendants, not to enforce it, runs contrary to the mandatory injunction relief that has been prayed and already discussed here in above. Trial court, without noticing the relief, erroneously granted the plaintiff only seeks to execute the MOA.
I think you can conclude now. Formulate your points. We'll call this.
So, yes. Now, my lords, my
Formulate
points
your point.
that, yes, formulation. My lords, as is very well settled in various judgments, including Dahiben, etc. In an Order 7, Rule 11, one can only look at the plaint and the plaint alone. I have pleaded in the plaint that mine was a concluded contract. The MOA is actually a formality which needed to be my lord, executed as in signed by them. So according to me, in the plaint, it is very much a concluded contract. I have put in evidence to show that it was a concluded contract. And the court could not have in 711 passed any kind of value judgment on whether this was a concluded contract or it could have been superseded by any flat purchase agreement, etc. So the court clearly travelled well beyond the narrow confines of 711. Then, my lord, second point is that, which I've already actually mentioned, that it is well settled in a line of judgments. My lord, 68 Kolipara, 3-judge bench is that once a contract, the vital terms are agreed upon between the parties. Whether they have been formally executed or not is inconsequential to the existence of the contract between the parties. The contract has come into being merely because it requires a formal MOA to be signed and executed, does not detract from the enforceability of the contract. That is, my lords, Kolipara and other judgments, I'll point that out. Third, my lords, that the court could not have gone into matters of evidence or merits.
It hasn't gone in.
Yes. And fourth, my lords, as far as the prayers are concerned, let me assume against myself, and I said, my lord, very clearly that my prayer is clumsy. It's clumsy. If, my lords, the case law again on this is, if it's a defective prayer, it can be amended, number one, if it is to be defective, that is. Number two, even if one prayer stands, my lords, if I have, say, 6 prayers or 8 prayers and even one is good, my lord, that is good enough. I cannot be knocked out wholesale under Order 7, Rule 11. And my lords, any any issues with, say, court fees or valuation or anything, again, an opportunity has to be given to me, and it's a curable defect. My lord, I'll just, the case law, may I point out in.
Okay. That's all well
Your Lordship,
known.
I can hand over the compilation. I've got the, we've put the relevant fact for each of these propositions, my lord.
Mr.
I'm
Sudha,
grateful.
thank you.
Please, Your Lordship. My lords, Order 7, Rule 11, my defense cannot be looked at. These are all axiomatic. My defense cannot be looked at. Plaint has to be looked at. And the documents relied on in the plaint. My lord, 2027 SCC 366. Kindly just read one small sub-para, not even a para. I won't take your lordship's time. At page 378, 23.8, 23.8, para. Having regard to Order 7, Rule 14 CPC, documents filed along with the plaint are required to be taken into consideration for deciding an application under Order 7, Rule 11A. When a document referred to in the plaint forms the basis of the plaint, it should be treated as a part of the plaint. In exercise of power under this provision, court will determine if the assertions made in the plaint are contrary to statutory law or judicial dicta for deciding whether a case for rejecting the plaint at the threshold is made out. At this stage, the plea taken in the written statement, etc., which I'm in full agreement with, my defense is of no consequence. My lord, the cause of action, and I'm challenging, my lord, the suit on two bases. One is, does not disclose a cause of action. Second is against law. And I'll show your lordship straight away why I say it. What has not been shown to my lord is the very document on which the plaint was based, which is the MOA, which is at page 91. Kindly take that now. I assume it. I assume the NO. Let me take the assumption. There is that MOA. I take that document. Please note one important factor. The MOA is dated 17/3/2003. 2023. 17/3/2023. The sale deed is dated 3/4/2023. That is within 2 weeks of this MOA. Both these are the documents on which the suit is filed. Now kindly see page 91, the MOA. Admittedly, my lord, not executed by me, but we won't go there. I'm taking their case at the best on the plaint, which they themselves say not executed, but they say a concluded contract. All right, concluded contract. What is the contract? Page 92, my lords. Page 92, clause 1. The vendors have offered to sell, convey, transfer, assign all their rights and interests over the scheduled property to the purchaser for a total consideration of 58 crores 60 lakhs. That is the consideration. And the purchaser have accepted the said offer, agreed to purchase the scheduled property free from all encumbrances, claims and demands for a total sale consideration of 58 crores 60 lakhs. This is the total sale consideration as per their MOU. I'm not going on the sale deed, their MOU. Then, I'm going to read all, please. Then please come to page 94. Clause 11. That the vendor has not delivered any original title documents or revenue records relating to the scheduled property to the purchaser under this agreement. That is the MOU. 13. That the vendors have not delivered possession of the scheduled property to the purchaser herein under this agreement. Now, my lords, kindly come to refurbishment and leasing. It is a head. So, the first part was sale consideration is 53 crores. Now, the building is presently unoccupied. There is no electricity service connection. Building also requires various refurbishment works to be carried out to make the same into a tenantable condition. The details of the refurbishment work, hereinafter refurbishment works required are to be carried out are as set forth in Schedule B here too. Kindly see Schedule B at page 100. Page 100. refurbishment works to be appended. Finding is there is no nothing appended. There was never one. To be appended.
What is page 100? We don't get it.
Page 100, Mother. Schedule B. So they were meant to carry out refurbishment works because the building was not habitable, tenantable, had a lot of work to be done, to be appended. This is on 17th March 2023. This was never appended. The courts have also found it's not their case that there was any such Schedule B document. Now, please see further. There shall be a defect liability period of 1 year from the date of handover of the building after completion of refurbishment works and leasing of the entire building. Vendor undertakes, that is they, to arrange for leasing of the building as per the basic terms and conditions hereinafter basic lease terms set forth in Schedule 6, that is at page within a period of 6 months from the date of the agreement. Mala, that is at page 101, which will say the lease rent should be 40 rupees, what it should be, page 101 is Schedule C. Now, my lord, kindly see 18. In consideration of their doing this,
18.
Clause 18, page 95. So they have to do 15, 16 and 17. In consideration of doing this, the total amount payable by the purchaser to the vendor, now please see this, my lord, for carrying out the refurbishment works and leasing the entire building shall be 53 crores. Hereinafter refurbishment leasing consideration, which shall be payable to the purchaser in the manner subject to any deduction, etc. Paragraph 20. Paragraph 19 and 20. Subject to the deductions adjustments, parties agree that upon vendor completing the refurbishment works, this is the document which is part of the plaint. For each floor of the building, vendor leasing the same, the purchaser shall pay a sum of 53 crores upon their refurbishing and leasing the building. Then the cause of action arises for me to pay 53 crores. Now, clause 20. Upon the vendor completing the refurbishment works, leasing of the entire building, vendor shall deliver to the purchaser the various documents and drawings as per Schedule D. That's the documents of title. Then 22, my lords. Vendor shall arrange for the leasing of the entire building within a period of 6 months. 6 months. From the date of executing the agreement, that is on or before 30th September, in the event any portion of the building is not leased on or before, the vendor shall be liable to pay the purchaser liquidated damages equivalent to a monthly rent for the... So, my lords, it was, as my learned friend says, a distinct contract. No doubt. No doubt. I'm going on their plaint, I'm going on their MOU, I'm going on the basis, even though this MOU was never given effect to, it is a binding contract. So, it's a distinct contract. Now, your lordships will see, within 2 weeks, because the banks are pressing, all this is foregone, and I'm going to show your lordship how this is admitted in the plaint itself. I'm going to now rely on the plaint.
What's the date of the suit?
Malad, kindly see the sale deed.
Date of the suit?
5/4/23. The sale deed is at page 129. And kindly see the date of the sale deed, 3rd April 23.
The plaint is not 23. 5/4/23 is not the plaint. That's not correct.
June 24. No, you're talking about sale deed. June 24 is the sale, is the plaint. Suit.
You're asking plaint.
Suit.
June 2020. June 2024.
June 24. But the sale deeds, my lord, 17/3/23 is the document.
We know that one.
3/4 is the sale deed. Now, please see the sale deed. It's a complete document. This is also what they're relying on.
You don't need to show the plaint. You don't need to show the sale deed.
The reason I'm referring to the sale deed is the sale deed says 3 things. it does not say anything about the MOA. It is silent. MOA is not even referred to. Number one. Number two, the sale deed itself states the total consideration for the sale is this 58 crores for the, which is the sale consideration part. Number three, sale deed says I'm put in possession. I showed your lordship under the MOA, they're keeping possession. Why they're going to do the refurbishment? Under the sale deed, I'm put in possession. Number four, under the MOA, they kept the documents because they have to go get permissions, etc. The sale deed says the documents are handed over to me, which is a factual thing. They also admit I have the documents. Sale deed says nothing about the MOA, and it is within 2 weeks of the MOA.
Prior to the
Now, kindly see the plain.
Prior to the filing of the suit, what is the correspondence about the
after the sale deed?
MOA?
After the sale deeds.
Only the WhatsApp chats, is it?
That was prior to the MOA.
So therefore, they are asking you specifically after the sale deeds.
Nothing. Nothing. Now, what is important is, please see the plaint. My lord, which is...
Prior to the suit, there is nothing at all. Prior to the filing of the suit, there is nothing at all.
Nothing. Nothing.
That's a matter of evidence, my lord.
No. You file it with your plaint. It's a cause of action. My lord, one of the grounds under 711 is cause of action. Now, please see the plaint. Plaint starts at 402. And I'll stop with this, my lords. The plaint at volume 2, page 402.
Show me the.
They cannot lead evidence against their plaint. Please see page 412. Please see paragraph 15. Their own case is, the plaintiff was not in a position to carry out the refurbishment work for leasing the entire building to fetch a minimum rent of 40 rupees. In fact, etc., etc. My lord, therefore, they did not do the refurbishment. Within 2 weeks, they could not have done the refurbishment in 2 weeks. Their own cases, I didn't do the refurbishment. Where is their cause of action on that memorandum of agreement to even maintain the suit on this admission? And your lordship will, in that context, see the prayer. What is the prayer? Is for a specific performance for me to enter into an agreement. They want me to execute the agreement so that thereafter they can insist on performance, which performance will mean they must do the refurbishment, they must lease it out, and I have to pay them that money. It's not a mere question of paying the money.
What money?
That 53 crores which they're saying, which is the cost for, they will refurbish, they will lease out, and I pay them 50.
In other words, are you saying that because they could not
refurbish,
they could not refurbish, they lose that right?
Yes.
They lose that right.
Yes, that's under the agreement they're relying on.
Therefore, it's a case where it is an agreement which have mutual obligations under which they were supposed to do the refurbishment, and thereafter reimburse them for that.
After completion. That's what I read those clauses to your lordship. It says they will do 1, 2.
What happens to the contract? You're proceeding as if the contract is a valid contract.
I'm proceeding on the basis it's valid.
Therefore, what happens in the sense that does the contract have a clause which says that in the event they are unable to do the refurbishment, the entire contract collapses?
No. On the contrary, the sale is completed to me.
No, sale is not made subject.
So if they don't make, in which
Sale
case,
is not made subject to.
So my lord is saying, if they have a,
They are to be.
if they have a dispute under contract, there is an arbitration clause. I took that ground also. Please see page 97 of the MOU. I'm assuming the MOU is complete. Page 97, if they had a dispute, clause 32. Clause.
See what the trial court says about it. We have made up this new clause. Where is this in the MOA? These two clauses.
Okay, 1 second.
33.
Page 96, 97. Okay. You wanted to see what the trial court says on the arbitration?
Yeah, arbitration. Just keep that. Keep that.
Arbitration.
Malas, in fact, I put it in the written statement, I mean, in my 711 itself. Although I say there is no agreement, MOU, there's no contract, even assuming there was one, page 97, clause 32, there's an arbitration clause.
What happens to the arbitration?
Please see what the trial court says about it. The issue was.
Just 2 minutes.
We'll come back.
No, I'll take.
Can I just finish, my lord? I'll take 2 more minutes.
We are getting those. Yeah.
My lord, page 97, paragraph 32, clause 32, that in case of any dispute or difference arising between the parties under this agreement, that is the MOU, the parties have agreed to refer the same to the sole arbitrator who shall decide there's a dispute in terms of the Arbitration Conciliation Act.
Sorry, where were you reading?
Page 97, clause 32 of the MOA, which they are relying on.
Page 90?
97.
With respect to arbitration.
Yes.
So what's the point you're making?
My lord, the point I'm making is that assume they had a dispute. Now, my point is very simply this.
Even
the
if
agreement on which they rely as framed is very clear. If you do refurbishment and...
Even if there is a dispute with respect to the mutual obligations, the remedy is arbitration.
Arbitration. But I'm not even going that far. I'm saying, my lord, the mutual obligation, your lordship knows section 55 Contract Act, etc. I don't need to go there, but we have to look at the law also. Please just 1 second look at the mutual obligation. It is, they first have to complete refurbishment. They have to lease out. Thereafter, I pay the money. Now, my lords, if that is the case, and their own cases, I did not do the refurbishment, I did not do it, they cannot claim that money. They may claim for damages for any kind of breach by me or something else.
Refurbishment is first. Refurbishment is first.
First. Leasing is second. And payment is third. Your lordships will find this.
Right, we get it. You don't have to trouble yourself.
Because it says clearly, clause 20, my lords, clause 18, and says that...
Skip that, mister.
1890.
The point. Your point is...
So, my lords, they have to complete it. Now, assume they don't complete it. Assume. They don't do it. They say it's my fault. What is it? It's a suit for damages. You did not let me complete it.
That's why we are saying in the ultimate analysis and recovery. In the ultimate analysis, it's specific performance, and that specific performance is also for the purpose of eventually getting paid.
My lord, and that too, it's not a specific performance. There's a straightforward claim for damages. It's not specific. You can't direct me, my lord, because that's barred under the of the Specific Relief Act. Under Section 39 Specific Relief Act, the court, my lords, with mandatory injunctions, when to prevent the breach of an obligation, it is necessary to complete the performance of certain acts, which the court is capable of enforcing. Which means they're asking that I must now be forced to sign that agreement. All right, the case at best can be, even though you did not sign the agreement, it is an agreement. And under the agreement, I know I did not perform, but I'm entitled to damages because you ceased to let me perform.
All right, we'll ask her.
But this cannot be the relief. My lord, now let me see the relief. And my lords, they value the suit for 10 lakhs for mandatory injunction. My lord, kindly see the relief in this context.
Manipulated fabric.
Yes.
Which court is this?
Values of registry.
Correct. In the 10 crore, 58 crores will also come before the same.
But it was from court, now it is civil court. It was before only district.
District court. 15. Now, let me conclude by just reading page 414. This relief cannot be granted. It's barred by law. Let me explain, my lord, why. For a mandatory injunction, the defendants to execute MOA. My lord, that cannot be granted by the court under section 39 to execute an agreement. The court can say, I read the agreement from your WhatsApps and everything, and therefore I direct that you do X, Y, Z. And then, my lords, to recover balance sum of 53 crores, that balance sum is not payable because there's no balance here, it's only damages. They themselves say, I didn't do the refurbishment. So where is the balance? I'm going on the plaint averment. You cannot go, my lord, more than the plaint and the two documents they have relied on. Everything else becomes immaterial.
All right.
My defense is immaterial. Therefore, my lords, in any event, under 711, the suit cannot stand. And on demurrer, I took the argument, my lord, of arbitration on demurrer. Lordships, please.
How did the court deal with arbitration?
I'll show, my lord.
My lord,
The
page 488.
court at page,
488.
You are talking about single judge.
I'm talking about the division bench also.
Tell us.
I'll just take, my lord, straight to the division bench. Division bench, page 19, paragraph 30.
We are there. You're seeing that.
One more argument that was advanced by the learned counsel for the respondents is that the defendants had themselves relied on the terms of the MOA and argued that the parties had agreed upon an arbitration clause, therefore the suit was not maintainable. He would rely on the said clause, contend that the petitioners themselves fall back on the terms of MOA. It only goes to show they have agreed to the factum of the parties having admitted the MOA. It is not open to them to contend otherwise. You can't blow hot and cold. Either the MOA stands or doesn't stand. I am unable to countenance the said agreement for the simple reason that as a defendant, the defendant can take mutually inconsistent pleas and merely contending that there was an arbitration clause in the MOA, suit was not maintainable, cannot be a ground to hold that the defendants have accepted the MOA. And that, my lords, will see at page 423, the trial court.
That he is not dealing with arbitration.
No, that's...
He's not dealing with arbitration. What he is dealing with is
423,
that
trial
with
court,
respect to the proof of the MOA.
yes. My lords, they've
That
said
is
that...
right. High Court is right.
High Court says, since I'm agreeing with you...
That point is the High Court. Yes, Mr. Balbisi.
Yes, that I'm agreeing with you. And my lord, page 423 also, your lordship will find before the trial court also, the point had been taken that in that case, my lord. So, my lord, as far as I'm concerned, I don't even want to go to arbitration. It's their choice. But this suit cannot stand as a suit. That is my point.
We'll see.
If they decide to go to arbitration, my lord, that's a different matter. But it's not a matter that we should be referred to arbitration. That's the point I'm trying to make.
Well, the MOU is of 17th March, sale deed of 3rd April. One para of sale deed, page 121. I'll read it, Malad, when you not specifically open it. Or rather, Malad can have it, page 121, para H.
Your lordships, excuse me, my lord. Can I?
So I'm presuming that on 3rd of April, the plaintiff knew that they want to retain the second part of their MOU. That's what the claim is. Which is refurbishment, 58 crores is going to come to me. And I can't imagine that they forgot in the month's time because 17th of March and 3rd of April is even less than a month. H says 121 and it's a sale deed. And whereas the vendor represent, there is no claim, encumbrance, mortgage, charge, lien, attachment, pending threatened or anticipated litigation, requisition, acquisition or notice in pursuant to the scheduled property. Further, the purchaser that there is no prior agreement to sell in respect of scheduled property with a third party, and further assure the purchaser the vendor can convey an indefeasible right, title, ownership, interest in the scheduled property. So there is no whereas claim. This document is not under challenge. And my lords have posed the first question on day one, that is this document has been tested for challenge before the competent authority under the applicable act of the state? The answer is no. This being one of the major thrust by the High Court on page 19, para 29, to say the plaintiff has not challenged the sale deed. If this being the matter of position and 121 giving me unencumbered with no claim right to today, within a span of 16 days to say that no, now after a year I'm filing a suit, therefore I have a claim. Let's test this proposition. I'm not admitting document. Mr. Sundaram on Demeter was generous enough. I'm not. It's an unsigned document which is admitted position. Only claim is I send to you, you're not signed.
We got the point. Then what's the other point?
Second point is, the prayer my lords have read,
You've sent.
today before this honorable court to say that it's a clumsy drafted is no answer. The court on the day when they were looking at a prayer in the suit and the pleadings and the attached document was looking the way the plaintiff, it has been presented. You can't improve saying that please change my prayer. You could have tested in a different manner. On particular day when the plaint is to be looked, the prayer is to be looked into it. Ultimately, if we look at it, they need to say that is it a specific performance? Specific performance of what? Are they saying that these sale deeds should be demolished and therefore should be reconveyed to them? It's not being done. Or it can be damages, which they say that ultimately the language also of the prayer my lords have seen it coming out as if it's a recovery they want to make out of it. If that is a recovery they want to make out of it, that's not the pleading which is being done in that case.
Thank you. Madhuri?
One second. For R, just I take only 1 minute.
I'm sorry, Mr.
Mr. Balbir Singh, you're done?
R6.
Balbir Singh, anything further?
Well, the only last thing which I want to submit is, well, when we look at the 711, the pleading should be very specific. The vagueness of the pleading cannot be an answer. The two paras which I want to read, Mr. Sundaram has, although read one part of it, page 379 of the judgment, only two paras because it's a 2020 judgment.
And chance given.
Which one, this judgment?
Yes. Only two paras.
Oh, it's already there.
So 20 page 11 on the top and para 23 after reproduction of section 11, rule 11. Kindly see what they said, 3.2 thereafter.
Yes.
The remedy under rule 7, under order 7 rule 11 is an independent and special remedy wherein the court is empowered to summarily dismiss the suit at the threshold without proceeding to record evidence and conducting a trial on the basis of evidence adduced. If it is satisfied, the action should be terminated on any of the grounds contained in the provision. The underlying object of 711A is this: if the suit, no cause of action is disclosed, the suit is barred by limitation under 11D. The court would not permit the plaintiff to unnecessarily protract the proceedings in the suit. In such a case, it would not be necessary to put an end to sham litigation. The further judicial time is wasted. Now, if we look at the nature of the pleading which have been made, Malats, and the prayers, they are not certainly in sync. On a one hand, say that I have a concluded contract. The concluded contract means what? You reverse the sale deed. You say that the sale deeds are bad, whereas the sale deed is not under challenge. Then the prayer is so vague to say, which is admitted position, that it's the clumsily drafted. That's no answer. 711 should be, once the suit is filed, it should be precise and specific. It can't be today to say, coming before the Supreme Court, I want to improve my prayer. That can't be the ground. The High Court looked at it, and on that basis, court, after looking at all documents, and especially most important document is if sale deed is not challenged, they have not retained any claim and charge against that. There cannot be a step today to say this document, unsigned document, be enforced.
Thank you.
Rectify for R1.
What's the
We have
point?
to kindly come to cause of action class in place for me.
We've seen it.
The court fee paid for prayer number 1 is 30,000 rupees. Though they sought for recovery of mandatory injunction, recovery of 58 crores and that, they paid court fee of 30,000. Other two release for only for permanent injunction. Secondly, admittedly, they executed sale deeds in favor of defendants 2 to 8. 8 sale deeds on 5/4/2023. The receipt in the sale deed says, my lord knows, my lord, normally possession follows title.
Admittedly, 8 registered sale deeds have been executed within 2 weeks from the date of alleged MOA. The sale deeds have not been put to challenge at all. Even in the CASA fashion class contains only 2 lines.
That's argued.
Yes, ma'am. Contains only 2 lines. Therefore, it is also a well settled position of the plaintiff has to succeed and perish on his own pleadings.
On its own.
He is not entitled to take any inconsistency.
We'll ask.
Okay.
Thank you. Yes.
Well, not first
Just
and
answer to those 2 questions.
I'm sorry.
Just answer to those questions.
Yes. So first and foremost, since the question from your lordship came on the arbitration clause. Now, my lord, as far as the arbitration clause is concerned, it is contained in the MOA, the formal document which I signed and which after preparing.
So therefore, the arbitration remains untouched.
My lord,
arbitration remedy for you remains untouched.
my lord, an arbitration agreement requires it to be signed by both the parties under Section 7 of the Arbitration Act. You cannot have a situation where you say that there is no MOA at all, it's a completely concocted document, and then it is your ground that, oh, there's an arbitration clause. You can't have it both ways. It's a completely mutually destructive argument. So, my lord, the question of my going to arbitration as the learned trial court holds is when the MOA is signed, it becomes a fructified agreement, which is why also I need signing of the MOA by him.
What did a single judge say?
Yes, the single judge at 488 paragraph 16.
But they have.
May I read it?
But it's not, the existence of the agreement is not denied.
My lord,
Existence.
he is denying it, and I am saying in 711 you cannot look
All right.
at any of
You make your point.
Yes. So my point is, my lord, there
Even assuming that it's an issue relatable to recovery on
Yes.
the basis of that agreement,
yes,
there is an arbitration clause to that effect about the recovery.
but he needs to
But the-
sign that MOA in order for me.
Therefore, it's specific. Purely, it's a
Yes.
specific
So, my
performance.
lord, that is why I said that.
Clumsy suit.
It may not be happily worded, but it does not, it doesn't fall to the ground. It's something I can cure the defect, I can amend the plaint, all that case law is very well settled. I'll show that to your lord. So as far as, my lord, arbitration clause is concerned, he's cutting at his.
What have you done after the sale deed was executed?
Yes,
Why
now,
did it take,
that's very important.
why
very
did
important.
it take,
My lords,
were there any letters you wrote with them?
Yes, so there is certainly
Calling upon them to
on-
enforce and execute
Yes.
MOP?
So please see that same WhatsApp chats, it continues.
Before, sorry, you didn't conclude about the sale deed, about the single judge. What did it say? You don't show us
About the
arbitration.
488. Sorry, may I read para 16 at
No,
4?
we just want you to tell us what it is.
So basically it says that unless the alleged MOA is executed
the
by
point.
first defendant in favor of plaintiff, the arbitration remedy cannot be invoked against the
Okay,
defendant.
we got it.
And therefore, we sought, in fact, they're saying here, the trial court says, since the plaintiff herein clearly sought for the relief to direct defendants to execute MOA dated 17/3/23 alone and not to direct the defendants to enforce the.
Got the point. What's the second point you're making?
Okay, so my lord, and second point, insofar as the sale deed, why I didn't challenge the sale deeds, my lord, there is no reason for me to challenge the sale deeds because the sale deeds is a part of the MOA. The MOA required these 8 sale deeds to be executed, 7 sale deeds to be executed, and that sum of total sum.
We get your point.
Right.
Your stand had been that these are linear in the sense.
Part of the, it's a step.
It's a step in further.
Yes, but my agreement is a composite agreement. You can't cherry pick what part you want and then discard the rest. It either stands on its own or it falls entirely, which is why I wanted execution of the full MOA and enforcement of it. Now, my lords, insofar as what is my correspondence? Did I say anything after the sale deeds were executed? Yes, of course I did. And I said it, there was this WhatsApp group going on, my lords, which starts at page 63. And since, my lords, I didn't get the opportunity to read this to my lords.
Messages.
I'm sorry.
Okay.
So I didn't get the opportunity to read the context of this.
WhatsApp.
The WhatsApp chats, because the negotiations are happening on the
We take it from that.
So, my lords,
We'll not touch that.
page 68 repeatedly talks about 105 crores, the entire amount. So what are we talking about if it's only 53 crores and you can walk out after executing sale deeds? What was the balance for? Number one. Number 2, my lord, so 68, 69, and on several pages we refer to the entire. Now, after these sale deeds are executed, my lord, the correspondence continues and we keep saying, please sign the MOUA and give it to us. Please sign it. Repeatedly we are saying this. So, my lords have noticed the MOAs, the sale deeds were executed April 23. And after that, if your lordships will see page, for instance, page 88, 89. 87. Good.
Minutes, huh?
Yeah, 5 minutes. At page 87, my lords, even on 7th, your lordships may just see this, 7th of April 2023, just a few days after sale deed is executed, we say bottom of the page, about 4 items from the bottom. Sir, our person says, sir, please confirm when we can collect the signed MOA. It goes on, my lords, at page.
WhatsApp messages.
Yes, we keep following up from, my lords, very soon after the MOA's, sale deed is executed. We keep following up that please give it to us, please. And for instance, gentle reminder, please share courier details of the signed MOA, gentle reminder. It goes on, my lords. My lords.
Between what? Between 3rd of April 2024 to June 2024.
Because at least May it's going on, May, June, yes. May, June it goes on. And my lord, what is it? My lord, in the middle, again, my lord, in fact, Mr. Sundaram had argued this part. My lord, just note 87, 88, 89 for the reminder.
Where is this property? In which state this arises out of? Which state?
Old Mahabalipuram.
Chennai.
It's called Oyama.
Okay.
Oyama is old Mahabalipuram.
Tamil Nadu.
My lord, Mr. Sundaram's argument was that we did not.
Parallel to East Coast Road. East Coast Road on the left hand side, Bay of Bengal. This is parallel. My lord.
Nothing will come to us.
So,
yes.
My lord, the bit about the refurbishment actually not being carried out by us, and therefore there was no question of us asking for the amount. I'm responding to that point. My lord, it was a part of the MOA as and the agreement as concluded between us, but to be formally.
We'll consider.
Point number 1. My lords, please. Now, in the plaint, my lords, we have clearly pleaded at paragraph 14. Just double check.
That we have seen. You have read the whole thing.
That we went. I had read that portion to my lords. My lords, para 16. Para 16. We've said that we were ready with this reliance. Sorry, para 15. 1-5. Para 1-5, not 16. My lord, page 412. We've explained that we were ready with this Reliance Smart. We had a letter of intent signed with them. But because they didn't provide the title documents, they didn't act diligently, and therefore we were not able to proceed. We want to do the work. We want the, and therefore we are saying in our prayer that first sign the MOA, then we act upon it. And if you can't do it, only then, my lords, there is a recovery of the entire amount. My lords, I just want to show that to your lordships because my learned friend also read the schedule being empty. Why is the schedule, as far as what are the details of the refurbishment work, why is it blank? Now, the reason was because they say in the correspondence by WhatsApp, they say that, look, it will depend on what the client wants, that individual client who comes in as the lessee. He will decide what way he wants to have it refurbished. So you wait for that. So, my lords, that is at page 70. Just give this to me. My lords, it says in the mid on 11/3/2023, we say it will be governed by the client's requirements as.
Okay. Got the point. You got the point.
So, my lord, that is also.
There's a reason. There is a reason why.
There is nothing to it. And my lord, these are little, completely little, these are nitty-gritties. So long the law says that so long as vital terms are entered into and agreed upon, these details don't matter. Therefore, my lords, I am saying that I cannot be non-suited by them.
Item number 22,
Come back.
under 142.
Come back. We're coming back.
Anything else?
Sorry?
Ask somebody to be present.
Obliged.
Settled.
Lordship, my case is amicably settled and then
Plus.
been filed under 142 and I have to give the demand draft to my learned friend today.
Nobody is there?
Sorry, sir.
They are informed by the learned counsel for the petitioner and the respondent that the matter has amicably been settled between the parties. Learned counsel appearing on behalf of the respondent has handed over
The
a demand
drafts.
for rupees so and so to the counsel for the petitioner, which the petitioner acknowledges. The settlement, where is that settlement?
It's part of the application, Lord.
The settlement is taken on record, dated so and so, is taken on record. Are you also asked for quashing of proceedings? Also for
There is no FIR, Lordship. Only the respective suits have to be withdrawn. Divorce case and HMA case will be withdrawn and the transfer petition which is there before this honorable court.
we will dispose of the transfer petition in terms of the settlement between the parties. Anything further you want? Any further directions? Nothing.
No, nothing at all. Lord.
Very well. Simply, 142 orders to me, na?
Mutual consent decree has to be.
The fit case for exercising jurisdiction.
She's reached. I apologize, my lord.
Doesn't matter.
I've handed over the draft.
So, okay, we have allowed it. Thank you. Who was the mediator? Acha.
1 second.
How can you forget her name? So,
Yeah, Mr. Raghavendra.
okay. उसको लिख लेना.
Hello, sir.
Settlement is brought about through the mediation
Which is a
process by Mr. Raghavendra Tiwari. नाम लिख दिया. They are not mediator.
Proceedings, she's saying have to be quashed.
There is certain matters which needs to be quashed, which is para 8.
All that is a part of your settlement. All that will be done.
Okay, I'm so grateful. Consent decrees passed.
Yes, that will also be passed.
I'm so grateful. So grateful. Item 23.
Please, Your Lordship. Lordship, this pertains to the issue of moratorium issued by the National Commission for Allied Healthcare and Professions. Lordship, what has happened in this case is that I am a promoter of two colleges in Rajasthan. I am already running one of the courses. I applied for 3 more courses. But in the intervening time, the new regime under the NCHAP Act came into force. And initially they said there is no state council because of which we can't grant you permission for new courses. Thereafter, the state commission was also constituted. Now they are saying there are no regulations because of which we can't allow you to start new courses. And in the earlier regime, there was already an inspection conducted and I was found to be suitable for commencing 3 additional courses. I have lost last year, Your Lordships. I am only requesting that in the similar situation pertaining to Pharmacy Council of India, Your Lordships have taken already a view that these type of executive directions cannot be issued by any regulatory body under these specific statutes because that will be a clear infringement of 19(1)(g). And in this case, Your Lordships, the Act, NCHAP Act of 2021.
What act?
A national, I'll just hand National Commission for Allied and Healthcare Professions Act 2021. Section 40 is the one, Your Lordships, which
Give us the facts. Give us the facts.
Yes, Your Lordships. The facts in this case, may I just hand over a short list of dates, Your Lordships?
Inspection was conducted in 24.
20?
20.
Inspection हुआ? For offered DMLT course.
Your Lordships, this act came into force in 2021.
Tell us what it is. Just give us the, what is the National Commission for Allied Healthcare?
Allied and Healthcare Professions Act 2021.
Central Act, right?
It's a central act, Your Lordships. And 2021, Your Lordships, I got a permission for running one of the courses called as Diploma in Medical Laboratory Technology.
This medical council is under which act?
Your Lordships, it's the commission is under this
Rajasthan Act.
act only, Your Lordships.
This Rajasthan Paramedical Council is under this act only.
No, Your Lordships. The Rajasthan Paramedical Council, Your Lordships, was under the erstwhile regime of paramedical councils. It is a state act, Your Lordships.
State act. Then what happened?
Thereafter, Your Lordships, I filed a
issued order on 27 granting approval and recognition to the petitioner to offer courses in diploma.
Yes, Your Lordships.
Medical laboratory
Yes.
2021.
Yes.
Okay, then
thereafter, Your Lordships, I applied for 3 more courses, and since they were not deciding on my application to commence.
So distinct from DMLT, some other course.
3 more courses, Your Lordship. Diploma in Radiation Technology, then Electrocardiography Technology, and in Operation Theatre Technology.
Then petitioner filed. Then you filed a writ petition.
I filed a writ petition, Your Lordships. Since this inspection was being delayed.
Not inspecting the college for
Yes, Your
granting the permission.
Inspection
for these 3 courses.
Yes, Your Lordships.
Then what did the High Court do? Disposed of the writ petition, directed the paramedical.
Yes, Your Lordships.
To conduct inspection
of the petition
and
consider its application, Your Lordships.
Made an application to the law seeking
Yes,
permission.
Your Lordship. 17
Paramedical issued
7,
order on 7/8.
Yes, Your Lordships.
Approved.
Yes, approved, Your Lordships. Consider application for approval to run courses in
Inspection
DRT.
team appointed
Yes.
by the paramedical conducted inspection.
21/8/2024, Your Lordships, the team appointed by the Rajasthan Paramedical Council conducted the inspection and found that I fulfilled the requisite infrastructural facilities and faculty strength to offer the courses in these 3 additional courses. Thereafter, Your Lordships, since the 2021 Act had already come into force, the Rajasthan State Allied and Healthcare Council on 22/8/2024 and Section 22 of the National Commission for Allied was constituted. Now, till here, there is no problem, Your Lordships. Thereafter, Your Lordships, 30th of August 2024, Respond number 1 ordered dated so and so, whereby it noted that Rajasthan Paramedical Council has been abolished after the National Commission for Allied and Healthcare Professions Act has come into force. Now, the problem starts on 9th of December 2024. This is where the Respond number 3, that is the National Commission, issued a moratorium whereby it prohibited.
The National Commission or a council?
Commission, Your Lordships.
It's called the commission now.
Commission.
Okay, commission under the new act. Okay, all right. National Commission for the Allied Healthcare Professional Act.
And they said that if it is an existing college, existing course, you can give a renewal.
Prohibited.
But no new college and no new course.
National.
Thereafter, Your Lordships, on 14/2/2025, I again make a representation reminding that.
No, 1 minute. This 9/11/2024 issued by whom? R3 is the National Commission.
Yes, Your Lordships.
National Commission, not the state. Then
thereafter, Your Lordships,
you made another representation.
Yeah, another representation, Your Lordships.
Promptly.
And 10th of June 2025, the National Commission again issued a letter to all the state council reiterating that it has prohibited all the state councils under the National Commission for Allied and Healthcare Professions Act from granting permission to any application seeking permission to offer additional courses in allied and healthcare institutes such as that of the petitioner till regulation under Section 66 of the Act are notified. Then I challenge the moratorium order in another writ petition.
Are the regulations now given?
No, Your Lordships. No regulations in place.
Who is appearing for the National Commission?
Yeah, I'm appearing.
Now, Your Lordships, I'll just place.
No, recomplete it, please.
I'm sorry.
I could, by order dated so and so, permitted to withdraw the writ petition filed against the inaction of the respondent in not granting the approval of the petitioner's application. No.
Because the council.
Why do you want to?
Your Lordships, I withdrew it because the moratorium order was placed in the court. That was a writ petition which had not challenged.
So you filed a new writ petition?
I filed a fresh writ petition, 26/8.
What happened? Single judge?
Yes, Your Lordships. And confirmed by the division.
Single judge what? Final order so and so.
Dismiss the writ petition.
Erroneously dismiss the petitioners. Uphold the validity of the moratorium. Writ appeal.
Yes.
So what's your point?
My case, Your Lordships, is first that the first point which I'm making, Your Lordships, is that page 81, Your Lordships, there is already a circular in place.
What is 81 dated?
Dated 13th of June 2025.
81.
Page 81. Annexure P13. PDF page 138, Your Lordships.
What is it? 13th of June.
13th of June. Your Lordships may refer.
No, in your list of dates, which one?
No, list of, Your Lordships, it's not there in the list of dates, Your Lordships.
What is the date? What is the date?
Date is 13 June 2025, Your Lordship.
13 June 2025. 13th June 2025. What happens on that date?
Your Lordship, what has happened there is that the state of Rajasthan, Your Lordships, has issued a letter to the State Allied and Healthcare Council saying that till the time the new regulations or new system is in place under the new act, you apply the existing Rajasthan Paramedical Council Act. Page 81, Your Lordships. So my first submission is that this vacuum which the respondent number 3 is claiming may not be really relevant, because the government itself has said that till the time the regulations will come
Well, whatever, just because the regulation is not used, not issued, how does the act not come into operation?
Please. And second part, Your Lordships, section 40 of the
regulation is no basis not to act.
And Your Lordships, insofar as the section 40 of the act, Your Lordships, is why
the only reason, as you are saying, that for not granting you permission is because the Central Act has come into force from 2021. What does it repeal? Central Act? Or is it a first time act?
It doesn't repeal in anything, Your Lordships.
Just check it up.
And subject to the concurrent list.
No, is there a repeal provision? So therefore it's a first time.
Yes, no repeal provision, Your Lordships.
So it's in relation to concurrent list.
Yeah, 25.
What 25?
Of concurrent list. Entry 25, Your Lordships.
List 3.
Yes, Your Lordship.
So it has come into force. What happens to all the acts that the state governments have in the meanwhile passed? We are just asking you.
Yes, Your Lordships. So that act, Your Lordships, till the time the new, may I just read 81, Your Lordships, because that is how they treated
Yeah,
that is how they treated the existing state law in this case. Page 81, Your Lordships, Annexure P13. In exercise of powers conferred under Clause J of Section 30 of the National Commissions for Allied and Healthcare Professions Act 2021, the state government hereby entrusts the Rajasthan State Allied and Healthcare Council to perform the following functions, namely: 1. Decide all applications which were pending before the Rajasthan Paramedical Council for registration of paramedical professionals according to the provisions of the National Commissions for Allied and Healthcare Professions Act 2021. Clause 2. Till regulations under the National Commission for Allied and Healthcare Professions Act 2021 are framed, follow the provisions of the Rajasthan Paramedical Council Act 2008 and the rules and the regulations made thereunder, which are not inconsistent to the provisions of the National Commission for Allied and Healthcare Professions Act 2021, except the condition of having domicile of Rajasthan as mentioned in Regulation 42 of the Rajasthan Paramedical Council Regulation 2014 and 2022. So they said that till the time new regime comes, you apply the existing law, existing regulations, because evaluation has to be done under these regulations. So, notwithstanding,
This is the letter of the state government.
Yes, Your
Section 30. Functions of state council. It has a hierarchy.
That is issued by the Rajasthan state government.
That's all. Your prayer is just let's see what the High Court.
Last point, Your Lordship, page 4.
What is the High Court judgment?
Yes, sir. Page 3, Your Lordships. Para 5 is the relevant reasoning, Your Lordship. In view of the aforesaid submissions, this court is convinced by the order passed by the learned single judge while considering the factual matrix that once the new Act of 2021 is in place and it prohibits that until the regulations are framed in the new courses cannot be started, the same has to be adhered to. Any kind of retrospective protection in the light of...
Where does it prohibits? Where does it prohibit? Show us that section.
There is no section which prohibits, but because of that moratorium which I indicated, Your Lordships, on 9th of December 2024, page 44, that is a problematic moratorium. That is the one which brings in the...
We'll see that page 44.
Annexure P6, Your Lordships.
9th December 24.
Please, Your Lordships. This was specifically challenged by me in the impugned writ proceedings. Your Lordships will see para 3, clause...
1 minute.
This is constituted.
This is the action. This is the commission. This is the commission which will drafting. What is the date? 9th December 24. Till date, December 24 is operating.
Yes. And page 470, Your Lordships, one of the PILs came to this court, Your Lordships. In that PIL, Your Lordship, this court observed the fact that despite 2021 Act, there is no regulatory mechanism in place. 470, Your Lordships.
Shows that?
470. The operative part is 473, Your Lordships. Para 3.
What do you this question? The application for employment of the chairman of the National Commission respondent is allowed. The commission for it's a different matter, right?
It's a different matter.
What happened to that matter?
Your Lordship, it is pending, and recently, Your Lordship, one contempt application was also filed. Notice was issued in that.
In that
contempt application, Your Lordship.
Grievance.
This is that order, Your Lordship. Same writ petition, contempt application file, and both these things are tagged now.
So they have completely from 2021. When was this act notified? When was that?
25 May 2021, Your Lordship.
Huh?
25th of May 2021.
So after in this very matter, the contempt is filed, is it?
Yes, Your Lordship.
The grievance has been submitted. The maximum permissible extension was available to central and the state under 16 and the women. Then what was the directions here? The directions which have been sought in the present of Constitutive Council. What So what were the other orders in that?
Your Lordship, after that order, the first order, Your Lordships, which I just showed at 470, the matter was not listed for quite some time. Some compliance.
And then they filed a contempt petition in that.
Yes, Your Lordship. Contempt petition was filed recently, Your Lordships. And on 24th of February 2026, a notice has been issued in that contempt application.
Where, which show that?
Please. What happened? I don't know. It was supposed to be on 24th, but I'll just check what happened on 24th.
Where is the direction?
Shouldn't you have your case along with that?
Lordships, I am interested in starting the course this year. I mean, this may take it forward a little.
Okay, tell us.
That after the
just last one.
New Act.
Last one line, Your Lordships. 466, Your Lordships, is the portion of that Pharmacy Council of India matter where Your Lordships had clearly held that executive instructions cannot be impinging upon fundamental rights. There was also a similar moratorium in the context of pharmacy.
466 is what?
It's a part of a judgment, Your Lordship.
It starts from
428. Pharmacy Council of India versus Rajiv College of Pharmacy and another. Similar kind of moratorium in the context of pharmacy colleges. Your Lordships held that this kind of executive orders cannot be in place.
Supreme Court judgment.
Yes, sir. Lordship,
What is the name of this case? PCI versus
Rajiv College of Pharmacy.
What is the date of the judgment? 15/9/22.
15 September 2022.
Saw that.
Yes. These are my broad submissions.
Yes.
After the new Act come into force, that all the state commissions are abolished. Now, the commission, the constitution and the commission has been complied and issued directions in the moratorium with regard to the new courses and additional intake. But Lordship may kindly consider Section 40 of the new Act. That is for permission for establishment of new elections.
So? Yes.
Yes, that coming to that section 66.
So what about 40?
40 with regard to the permissions of establishment of new health core courses is required under this Act.
So?
Then before that, my lord, section 66, power to make regulations.
So?
Basing on that, my lord, regulations are two committees have been constituted and it is consultation.
Who is the chairman?
Pardon?
Who is the chairman?
That's it. Chair. Committee members. Committee members.
Does it have a secretary?
Committee members.
Sir.
This is Dr. K.M. Annamalai is the coordinator. This is
not counter.
This is Dr. K.M. Annamalai.
Counter affidavit, page number.
This is I already counter affidavit filed, my lord.
No, tell us.
Page number 34.
Is there a CEO or a secretary? Who is there? Who
Yes,
runs this?
coordinator. There is another committee.
Resignation of the members, cessation of the members, meeting of the commission, vacancies. कौन सा ऐसा है सेक्रेटरी तो कुछ होगा
Section 3, Your Lordship.
just read.
The commission shall consist of the following, namely, a person having an outstanding ability, proven administrative capacity and integrity, and possessing a postgraduate degree in the profession of recognized category of allied and healthcare sciences from any university, with experience of not less than 25 years in the field of allied and healthcare sciences,
That is
out of which at least 10 years shall be as a lead.
Where are you reading?
This is for regular.
Section 3.
3 what?
3 subclause 3A.
Proven administrator shall have the following name.
To be appointed by the central government.
Following shall be ex officio members. Who is the CEO or who runs it? Secretary. Who is the ex officio? Who runs the? Mr. ASG.
This, oh yes.
Who is the secretary or somebody who runs the commission?
The commission.
Joint secretary is there, is an ex officio member. Then who is in charge of the commission?
Under 66.
Designation 9. Versus meeting of the commission, office and employees of the commission, professional councils. Functions of the commission. Advisory commission. There is an advisory council. Why are you taking registrar? Online, central register, rights and central registration of
Section under 66.
Constitution member council state. It doesn't talk about any general secretary or a
Section 3 complete constitution.
CEO or one. Central registrar must be. It must most probably be headed by a central registrar. Tell us.
Yeah, as per Section 3A of the new Act, a committee has been constituted, that is para 7 of the counterman. But
counter nikalna. Yes. Then? So, we are on simple question. So you all people have been sleeping, that's all. So what a shame it is, from 2021 the act has come into force. Nothing has happened till now.
This is
how you virtually render a parliamentary enactment redundant by not appointing authorities, officers. Who is the CEO? You will ask him to be present in the court. Who is the joint secretary in charge of this?
We will take in certain steps.
No question of taking. You won't do anything at all. We will ask the joint secretary in charge to be present tomorrow.
No, the commission is already, regulations are under final stage, my lord. That is.
You can't stop enforcement of of the provisions of the act just because the regulations are not notified. How long will it take? 2021 act. We are in 2026.
This is at the final stage, my lord. The committees are already drafted and consultation process is also over.
That doesn't matter, but the act has to be implemented. Just because you don't notify the regulations, you will freeze the act, is it? Who has filed this affidavit?
Who?
Working Under Secretary, Government of India. Under Secretary.
Under Secretary.
What does he know? Composition. Number of members. Member and absent chairperson. Charitable trust. We'll list it tomorrow, take instructions.
ask the CEO to be present in the court. Whoever is the officer in charge, list tomorrow. List this case tomorrow. In the meanwhile, the officer
Your Lordship may grant.
in charge of the council, just ask him to be present. We are not going to send him to contempt or anything. We're going to ask him what's happening. The senior most officer of the National Commission for Allied Health Care, be it under the statute or the ex officio member, comma, maybe the joint secretary, will be present in the court tomorrow, informing the state at which the stage at which the provisions of the act, implementation of the act are pending. Some day after tomorrow.
I am permitted to withdraw and will within week one will file submit detailed.
We are not going to, it's not a contempt, don't worry about that. But you just want to know that why is it that for days on, for courts are issuing contempts, some other, we are not interested in contempts. But why is it not being implemented? What is the reason? Is there any difficulty in implementation? Because you on the one hand, you have frozen all the state statutes.
It is true.
State statutes are not able to work because the central statute has come. And then central statute from 2021.
The committee is appointed under Section 3 has already taken steps, appointed 2 committees and consultation process is over.
In any event,
consultation process is also over, Millard. That
in
now
any event, what we are asking is merely because regulations have not been put in place, how can you not implement the act? Day after. Next.
So this is the matter where the petitioner is an IPS officer who wants to take VRS, but Union of India is opposing. Mr. Ahmadi is leading us in this matter. I know it's little late to take Passover, but if it's possible.
Everybody is in court 1.
No, he is in court 2. He is in court 2.
Passover, what do you want? Passover?
Passover, because we don't want to delay the hearing also, because he has been waiting.
They'll give us another day. We'll fix it up, some of the matter.
Or otherwise, Lordship, I start the matter.
Whatever, we don't mind accommodating. We'll take it up from somebody. Or the next case.
Some date, if Lordship may give some shorter date.
You can give a short date.
Deeply honored.
Item 25.
Please, Milos. Milos, in this, Milos, at the outset, Milos. Please, Milos. Milos, in this, at the outset, Milos, last year I have taken admission in Palampur in the veterinary college.
One minute. What is this about?
UGC NEET Milos veterinary course 2024. Now, before I start, Milos, I want to press this matter, but the petitioner has taken admission in Palampur last year, Milos. The High Court's order is in teeth of.
No, it's okay.
But Milos, the High Court order is in teeth of your Lord's judgment, Anushka's judgment, Milos. I'll just give me 5 minutes, Milos.
What do you want? You want to argue?
Please, Milos. Those are my instructions, Milos. I'm seeking a transfer.
But you said he has already taken.
But I still want to go to Ludhiana, Milos, because my father is there. And I was wrongly denied the admission.
That's an independent thing. You apply.
No, Milos, I fell into the criteria. They wrongly asked an NRI fees from me. I'm a OCI card holder. While Anushka's judgment, Milos, I'm before the cutoff date, Milos. Please have page B for a moment. Page B. B. Synopsis.
You apply.
No, Milos, there's a slight issue in this, Milos. They are seeking to charge the NRI fees. I am entitled for normal fees, Milos.
But you have already joined somewhere, right?
I have joined, Milos. I can't conceal that. I had to bring that before my Lord.
Saying if you are treated as a regular seat which is available for an Indian citizen, then you will be able to pay a lesser amount.
Please, Milos. The amount, there's a huge difference in the NRI amount and the normal amount, Milos. And
okay, which is the clause you say?
Please have page B, Milos. I've culled out the judgment also. Page B of my synopsis.
Shows the judgment.
Please, Milos. Milos may have.
I've given the list of
appearing?
clause.
Who's appearing?
2023-11 SC.
Sir, you are there?
The state and university has to answer this. Because in fact, it's the university because it's an autonomous body. It has its own fee fixation. Very well.
2023-11 SEC 209, my lord. That's the judgment.
You're saying it's covered?
Squarely covered.
Doubt. They argued this.
In fact, before that, please have page 45, the prospectus. Then will me read this judgment.
I have a vague recollection of this one. Isn't there a judgment of
Please have page 45.
Deepak Mishra on this? Anyway, we'll see.
Please have page 45, my lords. With this, please have 45 of the paper book. Page 45, the first paragraph. It says that they'll abide by this judgment, my lords. Page 45, the prospectus of the paperwork, my lords.
By this judgment.
Please have page 45 for a moment, my lords.
What does this judgment say?
Now, this cutoff date is of.
No.
Please
it
have.
says, how does it is made applicable to you?
Because I'm an
NRI.
No, because I'm an OCI card holder.
So OCI card holders will be entitled to
before
the same position as that of an Indian citizen?
Before 4th of March 21, not after that. That's the line. My OCI card was 2016. I was born in Canada, but I've been schooled here. My parents have retired here.
Post 20, the position is that
21. Post 21, it is no more.
They are not.
That's the judgment.
I'm in 26 now.
But my OCI card is of 2016, my lords.
Yeah.
My lords, allow me to read this judgment, my lords.
See, I remember to have argued this point
69 onwards.
At one stage, but then the issue is very contentious in the sense that,
then,
the number of seats are so very limited.
Because they had.
And Indian citizens are the first priority for us. So you leave them out and then we give it to NRI.
The seats are going vacant. When I was there, the seats were vacant.
That's a different matter.
The seats were vacant. In fact, last year also, I got into the Amritsar College. The VC refused to give me an admission, my lords. In Palampur, I'm paying the normal fees.
Okay.
I'm covered by this judgment, my lords. They are abiding by this judgment, my lords.
See, therefore, today your issue is not that this judgment, they have applied this judgment and granted you and collecting normal fees from you.
No. They want.
In Palampur, you got it?
Palampur, I got it. But this particular college, they want the NRI fees from me in 2024. I lost in a year also.
This college means which college?
GNU, my lords, Ludhiana. Ludhiana, my lords. Guru Nanak Dev University, there's a veterinary college in Ludhiana.
So they are collecting NRI fees.
They want NRI fees, my lords.
How much is that fees?
How
much is that fees?
Approximately 1 crore, I think, for the whole course. And the normal fee.
What's this on?
नहीं 1.1 lakh US dollar, my lords. And normal fees कितना?
We'll ask them. What do you say?
1 lakh per sem, my lords.
What do you say? What's the law? Who is to answer?
They have to answer, but law, unfortunately, we have lost in this judgment, so we can't really. Your Lordships did not agree with us, my lords, that we have done this for the protection of Indian students. And your Lordship said we are entitled to do a policy decision, but it will apply only prospectively. So anyone who.
So the previous decisions they have confined it to.
My lords, no, they have actually said that whoever has an OCI card prior to this cutoff date of 21 will be entitled to be treated. So that's the law, my lords. We filed a review, but the college will approve it.
But the fee structure is equivalent to NRI category.
But you're covered by this judgment.
Right? The similar situation, this court has also dismissed the same set of facts.
The cutoff date is what? Give us the date.
4th of March 2021.
2021.
4th of March, my lords.
Okay. What is the date? Why that cutoff date?
Because the OCI card has to be
OM date. That's the date of the notification. 4/3/2021. Okay.
There's no reference to that at all in the judgment. And so far as your client is concerned, why you fall before the cutoff date?
2016, and in fact, my
2016, what happens? What's the date?
I get the OCI card. And before that, I've been schooled in India from kindergarten to 12th. I've been here. My father was a professor in the same college. So he's retired. He can't actually pay the amount which they are asking. I don't have that kind of fees to put in.
But you have chosen this college for what reason?
I'm based in
was
Ludhiana.
allocated.
I'm based in Ludhiana, Milot.
No, this college you joined was were you through counseling allocated to this college?
All India counseling.
All India.
Category. Eugene, 15%.
So BCI has given this college for
So he has been paying the NRA fees pending disposal of the case.
No, Milot.
Yeah, he did not take the admission.
He
did not.
I came before the High Court. I came before this court.
College in Ludhiana ka college is not followed.
No.
But I actually have a submission to make on law. If my colleague wants to argue my law as an academic issue, and may I try to tell him to show to Lordship's how the judgment is not good
At this stage,
I seek admission in the college, Milot.
It's a sunset judgment, no? After 4/3/2021, but those who have been OCIs prior to 2021, they would have gone past that stage.
And therefore, give exam now or 11th for class. They could be active sunset. You can't add children who are born and had it.
Even children are being.
Has been added. The Lordship is considering I've argued that's why
No, I only seek an admission, Milot. I don't want to get into
The problem is it's not so much of an equity issue. It's not so much of an equity issue in the sense that you have, through counseling, been allocated to the present college, and the present college is charging you normal fees, but you want to shift to another college.
I was wrongly denied, Milot. I lost a year, and they refused. In fact, the prospectus refers to my lost judgment, and they refused to honor it.
It's
They
now
refused to honor it, Milot.
But anyway, today your position is good enough in the sense that you are paying the normal fees, and then only that you want to go to a better college is what.
I want
only
to
issue, right?
I want to stay with my. Yeah, I want to.
That,
shift to this
which
college.
year is your client in?
He's in first year now.
Oh, he's just joined.
Yeah, I lost a year, but this is a flagrant violation of my law's judgment, Milot.
You want to argue?
I don't want to. I want an admission, Milot. That's it.
You'll get admission after you argue.
I'll argue, Milot. I'll argue.
All right. That we can within the judgment we can manage.
I seek a midway, Milot. I seek a midway.
Yeah, he's not satisfied with this. Leave it at that.
Yes.
We will leave it at that.
Just a minute, Milot.
You might even be ending up if they succeed and if we accept their contention, you would be neither here nor there. Yeah, they are all part of our.
My learned friend can't reopen the whole matter, Milot.
You can't say. No. Don't go there. They are not to say that they have no allegiance on that. Just because an OCI is nobody is not an allegiance. Of course, I mean, for life we all go, and that's all one unit. You won't go that far. That you can say. What? That they are not saying. We'll see what do you want to do. You take instructions.
My law's migration to this college if the seats are available.
That you should apply independently.
Because they won't consider that.
You may apply independently.
Because I may say
make an observations if you apply for migration, that will be considered as per the rules.
May I say one more thing, Milot? Last year I got through the college. Last year again. And the Amritsar college was willing to give me admission in Punjab. The VC refused. Those are my instructions orally, Milot. Now the issue is that the VC is not willing to consider my case at all.
Those are different aspects of
I
it,
understand.
because there is no violation. Your case has actually been accepted and you've been
In the
working.
other college, in the other
Only question is, other college has nothing to do with this.
I understand.
Whether a seat is available, whether they permit you to.
Let them consider, my lords. I'll apply afresh. Let them consider.
Okay, you apply, they'll consider, that's all.
But some
So
protection.
we'll close this case.
Because some protection of the fees, my lords.
While we are not inclined to interfere with the order passed by the High Court, particularly in view of the fact that the petitioner has joined, what's the name of the college?
College का नाम क्या है? पालमपुर college का नाम क्या है?
What is the name of the college you have joined?
Palampur Veterinary College, Himachal Pradesh University, HP University at Palampur.
University, and is paying normal fees.
CSK Agricultural University.
CSK Agricultural, full stop. In this view of the matter, the questions relating to the larger question need not be answered, full stop. The learned counsel for the petitioner states that he would, his client would be interested in seeking, what is it, migration to another college which has offered him a seat if the petitioner makes an appropriate application to the concerned authority. The said application may be considered on its own merit and disposed of. With these observations, especially petitions and
Ludhiana. May laws may specify Ludhiana because I want to come back to Ludhiana.
Any college, migration you may apply, you may indicate wherever it is.
Deeply obliged.
Thank you.
Obliged.
Deeply obliged.
Better luck next time. Some other matter.
Obliged, my lord.
Thank you.
26 minutes for a while, madam. I'm requesting to pass over, short pass over. Mrs. Suri,
Pass over.
Mrs. Suri is on her legs in, she's on the way.
क्या करना है?
Short pass over, madam. Okay.
ठीक, हाँ?
I'm being led by Miss Madhvi, and she's also on her legs in Court 7.
MA before the new selection card, 250.
Yes.
Continuation of service. Pass over.
The question is whether they have been again selected in the
Yeah.
fresh selection.
You wanted from 2010 instead of 2021.
And that
Continuity of service. So,
Great.
I beg to appear.
yes, Mr. Patil.
My lord, sir, please issue notice and grant us an interim order.
I am for the respondent, my lord. I may be permitted to appear through which, my lord.
Yes, sir.
The short point, my lords, is that an Order 6 Rule 17 application was filed subsequent to my lord's trial having commenced.
Complaint, okay. Yes.
Subsequent to trial having commenced, and my lords, without any finding that it was after due diligence they had not made it. The trial court, my lords, allowed that application without considering this. The High Court also, my lords, interfered partly, saying that it will be from the date of the amendment. The fact remains, my lords, the prerequisite, the jurisdictional fact, which is mandated under Order 16 Rule Order 6 Rule 17 proviso, is not complied with. Two decisions of this court, my lords, squarely cover the point. 2009 to
What is it that they wanted to do?
My lords, they had filed.
They wanted convert from permanent injunction to possession.
Possession. Despite, my lords, they admitting in the cross-examination that they were dispossessed even before the suit.
And the application was amendment was made in 2018.
That's
The other side we have costs.
Yes, Chandrasekhar.
My lord, it is application.
So late. 4 years after that.
No, my lord, 2015 suit is filed. Application for amendment is filed 2018.
2014 plaint. Written statement is filed in 2015.
And 2018
The application comes on 2nd of January 2018.
This application, it's a relief of possession. That is relief of possession is ancillary to the main suit, my lord. And it is nothing but a curing an incomplete prayer. It is not changing the nature of the suit. In fact, it is a bona fide error.
When were you dispossessed? When were you dispossessed?
2006. My lord,
When
in fact,
were you
in the
dispossessed?
my lord, yes,
When were you dispossessed, Chandrasekhar?
my lord, at the time of filing of the suit, it was there, my lord, but there was an
then
error in the plaint contentions, so it was nothing but a rectification of error, my lord. It's a bona fide error.
It's not an
We
error.
are not,
It's not an error.
and my
You
lord,
are
it's
dispossessed and you file a suit in 2014 and leave out possession and only seek declaration and injunction under the pretext perhaps as if that you are in possession of the property. And now how could it be that after 2018, 4 years, you are adding
my lord,
possession?
They make
this
an
is
assumption
the,
that you're in
my
possession.
lord, this is nothing but existing rights, my lord. This is not changing the entire nature of the suit. It was ancillary.
Show us
Suit
your
for
plaint.
declaration.
Show us your plaint. Let us see.
Please, ma'am.
Possession. When you say that unless in the interregnum you lost possession, we can understand.
No.
Yes, sir, admitted.
Page 55.
It is at page number 22.
He is admitted in the cross examination as per 2006.
Chandrasekhar,
Yes, my lord.
we will allow this appeal.
My lord, that, my lord, it will affect the entire suit, my lord.
It has
Reason
to
is, my lord,
It should
my lord,
wrongly
now
not affect
High Court,
because it has
High Court
correctly
has,
affect.
High
The
Court
suit
has,
should proceed on the basis of how it was instituted in
my
2014.
lord, normally this court permits the amendment very liberally, my lord. Unless there is some serious prejudice, unless there is some serious prejudice to the other
State
side.
is the case.
My lord?
Cross-examination is over.
No, my lord. No, cross-examination,
Examination
it
of
was
the
partly
entry.
over.
And he admits
Partly
to
over.
take cross-examination.
Yes.
Page
Is there
50.
a stay here? We gave you a stay.
Yes.
Now,
It
did you
was
get a
part-
stay before the High Court, Mr. Patil?
No, my lords have granted assist.
High Court.
That I'm not sure.
Chandrasekhar, did the defendant, when he went to the High Court, he didn't get a stay?
No, my lord.
21, because 4 years it took for the High Court to decide after the trial court's judgment. So 2021 amendment, the suit proceeded, is it?
Yes, my lord. And in fact, High Court did not
Proceeding on the
commit
basis
it.
of this amendment.
It is left to the trial court to consider.
2021. Sir.
What is the stage then?
What is the stage, Chandrasekhar?
My lord, because there is a stay granted by this honorable court, now the evidence
Before we granted
stage it
stay,
is.
how many witnesses were examined? There's some discipline, just so casually you can't just. What is the stage? Only PW1 is examined, that's all.
Plaintiff is examined, my lords. Plaintiff examined in the cross-examination, he concedes to the fact that he had been dispossessed even prior to the suit. And thereafter they bring in an amendment saying that there was a mistake.
My lord, I take instructions.
Doesn't matter, you file a separate suit for possession if you declare. You
My
proceed
lord,
on the
this
basis
is
of
ancillary, my
declaration
lord.
and
We are
injunction.
not changing the entire nature of this one, my lord. And that separate suit will not be maintainable because whatever the possession is very much part of this. We are not changing the nature of the suit.
Declaration and.
There was a stay before the High Court also, my lords.
There was a stay.
Page 101.
In fact, opportunity to contest is there, my lord, to the other side.
नहीं मिलेगा इसको.
My lord, opportunity to contest is there to the other side, my lord, in the main suit.
We'll pass orders.
My lord, opportunity to contest is there to the other side, my lord. If the
You institute a suit on the ground that you are asserting that you are in possession.
My lord, may I
mention one thing? After so many years, you want to change the.
3 years, my lord. It is 2018. We have filed.
Why did you not ask for possession then? Tell us. Simple question. Why did more than anything, when you lost possession in 2006? Why did you mention in your plaint that you are in possession of the property? And why did you say it
Even after
Well,
they filed the written statement, in 2018 you filed the application.
Well, I admit that there's error, but it was a bona fide error.
Can't
Malad.
help you.
I
I
can
stick on
rectify
that.
it, Malad, in amendment.
All right, all
I
right.
may,
Okay,
bona
Chandrasekhar,
fide, Malad.
wait a minute. We'll just pass.
My mere delay will not cause prejudice to the other side, Malad.
All right, all right.
Some prejudice must be serious enough,
Listen,
Malad.
it is because the system, it's not a.
Malad, the entire suit will be affected. My humble submission is.
Okay, we've heard you. Lilina.
Relief granted. In this appeal is directed against the order dated 11/11/2024 passed by the High Court by which the revision preferred by the but you had preferred a revision.
Great notes. Yes.
By which the revision preferred by the petitioner has been dismissed and the order dated 2/3/2021 passed by the trial court, by which application for amendment of the plaint filed by the respondent has been allowed. Paragraph. Facts giving rise to filing of this appeal in nutshell are that the plaintiff filed a suit on 14/8/2024 seeking the relief of declaration that the decree in OS number 74/2009 was null and void. The petitioner also sought a relief of permanent injunction. Full stop. The petitioner filed a written statement on 2/5/2015 asserting that he is the owner and is in possession of the property. Full stop. A preliminary objection was also raised that the suit is not maintainable as the same is barred under section 34 of the Specific Relief Act as the respondents have respondents have failed to seek the relief of recovery of possession. Paragraph. On 30th March 2017, the examination in chief of the one of the plaintiffs as plaintiff witness number 1 was conducted. Full stop. On 3/11/2017, in cross-examination, plaintiff witness number 1 admitted that the respondents were dispossessed in the year 2006 and the 2006 and the properties currently used for commercial purposes with a market value exceeding rupees 10 lakhs at the time of the filing of the suit. Full stop. Thereafter, the respondents filed an application on 2/1/2018 under Order 6, Rule 17 of the Code of Civil Procedure seeking to amend the plaint to include the relief of prayer for recovery of possession. Paragraph. The trial court, by an order dated 2/3/2021, allowed the interlocutory application on the ground that the proposed amendment was necessary for a fair and complete adjudication of the controversy involved in the suit and as well as to avoid multiplicity of the litigation, subject to payment of cost of rupees 1,500. Full stop. The being aggrieved, the petitioners preferred a writ petition. The High Court, however, by impugned order dated 2/3/2021, partly modified the order dated 2/3/2021 passed by the trial court and directed that the amendment shall not relate back to the date of the suit but shall be reckoned from the date of application, that is 2/1/2018. To set factual background, this appeal has been filed. Paragraph. Learned senior counsel for the appellant submitted that the impugned order has been passed in flagrant violation of the proviso to Order 6, Rule 17 of the Code of Civil Procedure, as well as the in as much as neither the trial court nor the High Court has satisfied itself that the plaintiff, notwithstanding due diligence, could not have filed the application for amendment. It is further submitted that the suit was filed in the year 2014, whereas the application for amendment was filed in the year 2018. It is also contended that by allowing the proposed amendment, the High Court as well as the trial court have permitted the respondent to circumvent the statutory bar contained in Order 2, Rule 2 of the Code of Civil Procedure. On the other hand, paragraph. On the other hand, learned counsel for respondents has supported the order and has submitted that the petitioner shall have the opportunity to file to amend his written statement and to contest the suit, and no prejudice would be caused to the petitioner. Paragraph. We have considered the rival submissions made on both sides and have perused the record. A perusal of the order passed by the High Court indicates that that High Court has made a reference to the decisions of this court and has not assigned any reasons for dismissing the writ petition filed by the petitioner. The order exhibits lack of application of mind. Full stop. It is pertinent to note that the civil suit was filed in the year civil suit was filed on 14/8/2014. Full stop. The the petitioner filed a written statement on 2/5/2015, wherein a specific plea was taken that the respondents stroke plaintiffs are not in possession of the property and the suit is barred under Section 34 of the Specific Relief Act 1963. However, despite such a specific objection, the application for amendment was made after a period of approximately 4 years from the date of institution of the suit. Full stop. Neither the trial court nor the High Court has satisfied itself as to the condition precedent for making an as to the condition precedent contained in proviso to Order 6, Rule 17 of the Code of Civil Procedure, that notwithstanding due diligence, such an application for amendment could not have been made before the commencement of the trial. Full stop. For the aforementioned reasons, the impugned order dated so and so, impugned orders, both the orders dated so and so and so and so, cannot be sustained in the eye of law. They are quashed and set aside. In the result, appeal is allowed.
Great. And the trial court shall proceed.
The trial court shall proceed to deal with the suit on the basis of the original plaint.
My lord, I may be permitted to file a separate suit for possession in case.
That you take care. You don't say. If it is permitted, you file it.
My lord, one observation, my lord.
Without any other, our order is without prejudice to any other right that you may have.
That one observation, my lord, because the amendment is now set aside. I have.
It is like giving it to you on one hand and taking it away on the other.
Nothing, my lord. In my lord, it is clearly stated that they have forcefully evicted me.
Over now. Don't argue further. Next.
Item
29.
28 mentioned.
Deeply obliged.
My lords, in 29, I'm seeking a short passover, my lords. Main counsel is in
This stage at 3 o'clock, what Passover?
Kindly fix a date on next Tuesday. The arguing counsel.
Why don't you argue? Why don't you argue? Why don't you argue the matter? There are this government MCI policy. Why don't you argue?
The main counsel is not here. He's having some personal difficulty, my lord.
Okay.
Maybe post it for Tuesday. Fix a date.
Keep posting it and then again reposting every time.
And the NMC has not filed the counter yet.
Doesn't matter. You argue.
Main counsel is not here.
Next week, then. Yes. Okay, not next Tuesday.
Great.
May it please your lordships. Something very disturbing and very regrettable has happened, my lords.
Why?
The 20th of February, my lords directed the Commissioner of Police to ensure that peaceful possession is given.
Not given.
Now, possession on 18th of March, they gave a letter.
You are for whom?
I am for the complainant, the
the contempt now.
decree holder.
For respondent
Now,
number
what they have done is, 5th of March, we request the Commissioner of Police with a copy of your Lordship's order to ensure that a smooth transition is there and handing over of possession. The background of the case is this. These of 19
ultimately,
what has happened now is,
What possession or not?
possession is given. Your Lordship's direction to pay 1 lakh per month as damages for the last 8 months not paid. About 25 lakhs of water and property taxes not paid. More than that, what they have done is, from the 10th of March, they have broken down the premises, completely damaged beyond any redemption.
That's a different matter, Mr.
Now,
You
let's.
have got possession of the property.
I've got possession only symbolically now.
Civil and criminal cases against him.
Now,
How
no,
does
no.
it
I'm just telling your Lordships. The office report indicates that the Commissioner of Police has not given any compliance report. Rightly so, because when we go to the police, they aid him. They aid the contemners in damaging the property. When we give a complaint, they don't lodge an FIR. The magistrate issues a show cause notice to the police.
Okay, you file a criminal complaint.
Now at the instance of the magistrate, an FIR is registered last week. That's a different thing. That's a different thing.
We are simply, in a rent control matter, we grant the respondent
Now, please see what.
1 minute, some time to vacate on an undertaking. It usually happens. Now, this chap has gone to the extent of handing over the property but broken down those properties.
Yes.
These are over and above what we did. We will only ensure that you get back the possession. But so far as his damage to the property, non-payment of rents, all that is something.
That is part of your Lordship's order. 1 lakh
case.
per month. That's part of the contempt. That may be directed. 1 lakh per month. Your Lordship's directed in this order.
That we will do.
And my lords,
Where is our direction?
your Lordships will see.
Anyway, ask your client to be present.
Your Lordships will post
him to be present.
And also a direction to the police, my lords. They refused to act on your Lordship's order.
That's the lease. What they had handed over was the plain
Okay,
piece
all
of
right.
land. On that, the building.
Where is the rent control
The
part of
decree says the
1 minute, please. By our order dated 20th February 2026, we had directed possession to be handed over by 31st of March 2025. Full stop. We had also directed that the tenant / contemnor shall clear all past dues and shall pay rents at the rate of rupees 1 lakh per month for the said period. First off, Mr. Raghavendra Srivatsa, the senior counsel, submits that possession has been handed over. However, the property is damaged, and also that the past rents at the rate of rupees 1 lakh per month, as indicated by our order, has not been complied. Stop. We direct the concerned, the SHO, who is the person there?
The camp,
the
Inspector of Police.
Direct the Commissioner of Police, Belgavi City, Karnataka, to ensure that the contemnor is personally present before this court on the next date of hearing. List on so and so.
Milords, in
I have one
arrears
request.
are not paid. In the event the arrears are not paid before the next date of hearing, Milords.
That's not the.
And Milords.
Now don't overdo.
No, just one other.
In the event it is not paid.
So now, because we are past this order, you are willing to pay.
No, Milords, I'm in a precarious condition.
Precarious?
Because it's a the building, they had handed over the plain piece of land. We had built a building in 65, Milords.
For we don't have so much time, Mr. Raghavendra, to keep wasting our time in a matter.
My lords, it's not. May I submit? Just hear me out, my lord.
No. Just wait on the date. These are not matters, and people are without job waiting for years together, and we can't just.
And
spend time on a matter like this, post on 8th of May. Okay, उसका पहले लिखा है, present in the event, just before the court, 8th of May, in the event the petitioner, the contempt does not pay, does not clear all the arrears within that time.
And also the dues.
Dues
For
as-
25 lakhs.
My lords, that
As
is
per the-
disputable because he has
Not disputable, my lords. May I just give me half a minute? My lords, the decree is that when he vacates the property, he will keep the building with the permanent structures intact. That's the wording of the lease.
We are
That's the
learning a
decree.
lesson that, granting every case where we are
That
granting.
your lordships are right. Your lordships
Right,
are
you
right.
are
In every
saying
case
right,
there is a
next
breach.
time when you get a tenant's appeal, SLP don't argue for asking for time.
No, that's understood, my lords. In fact, as on this side, my lords, pursuing an
Every case
execution
with
is
the rent
far more
control matter.
beneficial.
Every rent control matter, this is happening.
Order 21 is far more beneficial.
Okay,
My
thank you.
lords, your lordships may also add that the dues, he will also clear the dues.
my lords, he's
If that is not paid, my lords,
All right.
for 1 year after your lordships had granted him time, he is in illegal possession, and for that period, why should I pay the taxes? He should pay. That's part of the contempt, my lords.
Call the next.
Skipper constructions downwards, your lordships have said.
Call the next.
My lords, somebody who is acting in gross violation, why should he retain benefits?
Thank
Please direct him, my lords.
Thank you.
I've given the, my lords, I've given the
We
calculations.
passed the order, we've directed him. Next.
obliged.
My lords, if I have to bear the damages, please,
Go ahead,
just hear me out, my lords.
Thank you.
Give me 1 minute, my lords. Please see.
Mr. Raghavendra.
The pictures are ghastly, my lords. If this
You
is
are
how,
entitled to file your execution petitions and do what you want. It's not an don't convert us into an executing court for all you are.
no, but
Don't
if the
convert
police,
this into an
if the
executing
police refuse to honor your lordship's directions, if only they had,
That's why we have told
this damage would not have been there.
court.
What do we do, my lords?
We have done what we can. Thank you.
Very
Next.
When we filed a counter, the same is not on record. Item 31, my lords, we filed a counter.
You have to, when section 11 is filed, you will have to, what is the position? What
My lords, the arbitration is not going on, my lords. It has commenced, my lords. My lords, they filed a counter yesterday. Last night, they have served us 400 pages, my lords. My lords may have it next week. We'll examine that and my lords come back on that. Voluminous counter, 400 pages they have filed last night, my lords.
Okay, next week.
Yes, my lords. Grateful, my lords.
Item 32.
Lordships, for last 4 years,
What is this?
they had mentioned in the before lunch.
Somebody mentioned.
It is actually Mr. Ajay, he appears for PCI. He was in difficulty.
Not today.
I have
Take it
only
up next
request-
Tuesday.
I have only one request. Next Tuesday, Lordships may keep it on a miscellaneous day on a Monday or Friday at post lunch. The only difficulty is that on
All days are miscellaneous days.
In fact, plus if I may indicate, we have already filed an additional affidavit. Plus initially the position for 2025 was that in terms of prospective plan, their application was not to be entertained. There was a complete moratorium so far as that district is concerned. Now, plus 25, 26, 27, we have filed an affidavit that we are going to consider their application in the light of new government order.
We are anyway, why should we, if all of you are asking for time,
Yes,
we'll put it up next Tuesday.
I was only suggesting that since their application is going to be considered, the office may call after little longer. So we will have the result also, maybe it may not
Lordships,
require any.
we will not take that risk. The only difficulty is at the stage where it is.
Want it next Tuesday? Or
Yes,
not
Your
all of you.
Yes, Your Lordship.
In the meantime, the state will to the counter.
Do that next Tuesday. Next Tuesday छुट्टी होगा शायद
Much obliged.
Tuesday अम्बेडकर जयंती है ना?
Holiday.
तो 21st को लगा.
That is that.
You are left very
Yes. I moved it. So sorry. Lordships, instead of next Tuesday, could it be on Wednesday or
21st?
21st? Right.
Because next Tuesday, uncertain whether the court is there.
Much obliged.
May
Yes,
please,
Mr.
Lord.
Venkatraman?
Yes, my lord, sir. Lord, on a very short, both of us are appellants. In 33.1, we have the appellant. In 33, they have the appellant.
We will grant leave in this, we will admit these matters.
Alternatively, may I want to suggest this, Manoj?
Yes, tell us.
Actually, core issues which leads to determination, two different benches, I'll have to show something. Same tribunal, two different benches have taken conflicting views. One of them has referred to larger. Can it go back to the same tribunal, one bench, and any time, so that there is some?
You all of you agree, and then
That is what I'm suggesting, bro. So that it can be decided within some timeline.
See, it appears that there are two matters,
Yes.
Two decisions.
Correct.
33.1 and 33.
Yes.
In 33, in 11th of September 2025's order, and in the earlier 21st of July 2024 order, they have decided 9 issues.
Correct. No, but the difficulty is before that the 11th.
9 issues you are saying irrespective of
Well,
its
before
decision which was
21st July order came to be passed, on 1st July, the chairman of the tribunal and the second member, who is the lead member, the
Tell
other
us
bench.
what you tell us what you want us to.
Yes, but
in our matters are not admitted.
Because 4 issues, 5 overlapping issues, which were 50% of the tariff. Conflicting views have emerged from the two tribunals of the same
We
apple.
are just asking, what do you want us to do?
Can
Grant
both
leave and
go
admit
back
the matter?
Can go back to the tribunal, one bench to be decided within timeline. Otherwise, the lordship has to decide everything one after
To remand, you want us
Yes,
to. What
that's
saying?
exactly.
Lordships, I'm
He's
being led by
asking for a remand.
But your lordships, the remand has to be in terms of the issues which have, whereas the dissent is there. The remand has to be limited only to the issues where there is dissent.
Then we have
Between the two benches, your
We
lordship.
will not adjudicate on this.
Yes, your
If
lordship.
both of you agree, we will do it. If you don't agree, we will hear the matter.
Yes,
Your Lordship, the crucial aspect here is that one matter.
Wait. Leave appeals admitted.
Your Lordship, may just hear me for 30 seconds, Your Lordship.
What's
Just
that?
30 seconds.
Post the appeals for hearing, regular hearing in the month of August. The month of August. For disposal.
And they have
Hearing expedited.
They gave an oral assurance not to present. They have not done it. They'll
We are
continue.
not passing
That's
any
right.
orders.
They'll continue that.
So, lordships,
Let
Your
it.
Lordship, there are
Obligation.
only 9 common issues.
lordships,
Which determines 60% of the
Neither
tariff.
here, if all of you are set for hearing, we will hear you.
Yes.
lordships, we are on for the remand, your lordships. I am only asking us, your lordships, I'm being led by my senior, Mr. Sibal. Can I ask for a short? Only, we are okay.
But the remand has to be for both.
You tell us, buddy, you tell us, what is to win, what's the way out? Do one thing, just sit with Mr. Venkatraman. Both of you sit down. If an order, we also agree, if an order of remand for a comprehensive order will inure to the benefit of everybody, because there are some orders positive, some orders negative, there are some orders where there is a difference of opinion. In view of all this, if some kind of a comprehensive direction asking the tribunal to hear all the matters and then pass orders, it will be beneficial for all of you. Give a thought to it and then come back to us. We will, whatever you want.
Because that's the best way to do it, to send it to a full bench there, Mullah. That's the
Give a
best.
thought and tell us.
We'll sit with him, Mullah, we'll organize it, Mullah. Instead of troubling your lordships with highly technical issues.
We will
Can it be a short?
not grant, we will not admit the matter. We will post it after 2 weeks.
Yes.
Yes, that's fine.
And come back.
We'll sit with the London.
Deeply obliged.
Deeply
the best.
obliged. That's the best way to do it. I'm obliged.
Apologies, also, we know.
And he come 5 minutes before you did.
No problem.
Right.
What is all?
Obliged.
I'm obliged.
That's fine, that's fine.
May I please, no, this is that question of the relaxation of the cutoff mark.
Hear this.
If your lordship will, it's covered, we believe, so it shouldn't take long.
Covered.
Preeti Shrivastava expressly says so, Manoj, constitution. So,
No, we'll have to hear it afresh.
but would your lordships give some date, because there is the other issue which I think your lordships took note of last time about the fees. Because what happens is,
This is the fees.
no, this is actually on cutoffs. This batch of 3 is on cutoffs, but it's linked in fact to fees, because you bring the cutoff lower and lower because people can't afford that. So then those who can afford are the ones who take advantage of the very low cutoffs all the way down to 0.
What is this fees matter you're talking about?
No. So I'll just explain. This is about the cutoffs. This case is about cutoff. The prayers are on cutoffs. So your lordships had put the question last time that if there are so many candidates available, why is it that they're not filling up?
It's not about the fees. It's
Yes.
about Post
Reduction in percent.
seats are not
Correct.
being filled.
Correct. So the seats don't get filled up. Because even though you bring the cutoffs lower and lower for those PG seats, why are the seats not getting filled up? Because the candidates are available. The reason is that because these are private seats, the fees that have to be paid are much higher. They're in crores as compared to thousands, which is why they take it lower and lower. In Preeti Srivastav, you said that it can't be filling up of seats being the priority. The priority can't be that at any cost we'll go down, all the way down and fill up the seats. Because quality of education
have come on record.
Yes, yes. Pleadings are complete.
I had an intervention application for PW. PW.
Disability.
Your Lordship.
This is PWD. It's
And
that way it's neutral. It doesn't really matter.
Millets. I appear in 34.4. My submission is that, Millett, there are more than 3,000 seats still available. The crores and crores is not correct for the reason there's fee regulatory committee. They monitor and they fix the fee. And that's why, Millets, if it's been lowered, at the end of the day, they pass the same test and they have to face the same ordeal with when it comes to the qualitative considerations.
My Lordship's indulgence for PWD purpose, there is no cutoff market reduction.
You're fixing a date, that's all.
So be it.
Do that.
Ms. Bhatti is also here, I think. She's
Fix it up for you.
As my Lord's team.
We'll examine this.
grateful.
Grateful.
35.
Notice very issue.
PWD candidate.
Is that
Matter is coming today.
Yes.
Acha. Chalice, have you gone through it?
I've gone through. I filed brief submissions and
You better wait for a while in this.
very well.
What's going on in Chief's Court?
That
This we were telling Mr. He informed you. This is what we were but we didn't know that the date was fixed in that. Now it's, I think, progressing. What do we do about this? We'll give a date in this?
Lordship may give a date, Manoj.
Mr. Man?
Next Tuesday, any day, my lord.
Manoj, the issue, the larger issues may await determination, but there is an administrative solution which has basically, my lords, the revenue department has built that place. They are willing to lease it. That need not be held up, my lords.
My lord, in fact, the question which was originally
We don't know what orders it. In fact, it was somebody.
There is an
somebody else
order
heard this
of
matter.
19th of August 2000.
Notice was August 19 when Justice Lalit and
Yes, my lord. There's a status quo on date with regard to
we'll give an early date.
question.
After 2 weeks.
Strike, my lord. I mean,
3 weeks.
may say this, my lord. After in your lordship's order, only your lordship said for the first time we were not parties. The HRNC board was not a party.
I see.
They have been impleaded. We have filed an affidavit quantifying it is actually in Inam land originally. Inam given to the.
There's a difference of opinion between.
Yes, no. Originally, my lord, it proceeded on the footing under section 34 of HRNC Act. Whether lease can be given is the question with your lordship. Now what they say is it's in Inam. So under section 41 only it can be given.
Okay.
So that is the only difference.
Okay.
There,
The issue has come.
the state government has to decide whether it is for beneficial interest of the temple.
Correct.
So it is only the quantum of money which has to come to the temple.
It's a financial adjustment which can take place.
Anyway, your
later.
lordship may keep it on some date. I'll not trouble your lordship.
We'll give after 3 weeks. 3 weeks we'll post on it.
The constitution bench judgment won't be available in three weeks.
Your other matters has to wait because directly in the point.
Yeah.
This is a more limited issue on section 34 and 40.
This need not wait.
That's
This
the thing.
need not.
Take it.
On a Tuesday, my lord?
Yes.
All right.
Anyway.
I'm appealing for respondent number 1 in this matter.
Lord, the last effective order in this matter, and I just point that out to your lordship.
This matter pertains to the pollution.
If you don't mind, just give me a minute.
Petitioners
Just have
will
a look
start
at-
always.
Have a look at the order of 30th April.
What is to be done today?
Lord, so, my lord, no objection.
If you are ready, we'll hear you.
The committee's report has come in, my lord. It's substantial compliance. So I was expecting perhaps they would like to file
I have
affidavit or something, my lord.
yes, and I'll be filing it tomorrow itself because of the delay of
Committee's report, is it?
The committee's report has come in.
The committee was directed to file this report by our order, right?
30th April, that's what I was.
By our
pointing
order
out.
dated
30th
30th April 2024, we had
25.
25, we had directed the joint committee to file its report. We are informed that the joint committee has in fact filed its report.
Correct. And I've also filed it
Learned
by
counsel
affidavit.
on behalf of the rest. You have filed what?
In affidavit, my lord.
Okay.
Action taken on that report. No?
Mr. Dhruv Mehta, learned senior counsel, submits that an affidavit in response and compliance has already been filed. Learned counsel for the respondent seeks to file objections to the joint committee's report. Permission to file objections is granted. This grant is granted. Objections may be filed within 3 weeks from today. 2 weeks from today. This case.
After 3 weeks, your lordship will have 2 weeks.
4 weeks.
Will उसमें direct respondent number 2 and 3 also to file the reply to the report because
For them, if they want to do it, they'll do it.
Obliged.
You don't need to nudge them.
That's report. 3 weeks, my lord. 3 weeks. 3 weeks, my lord.
Just thereafter.
37 is for final disposal.
Just on 4 हफ्ते के बाद.
This is a short matter, my lord. I think it may be disposed of.
It's for final disposal. Please, readings are complete, my lord.
Only TET, which is a qualifying exam. So there were 6 questions.
We are the petitioners. If we could start, my lord. I don't understand why.
Before us, some other case other than TET case, Mr. Patwala.
TET and West Bengal.
Super specialist in it.
TET and West Bengal.
Actually, it is like because these might look small, but on reflection we realize how important they are because it affects the primary schools. It affects our teachers at the youngest level, and we never respect them. We just don't care about how much salary they get. They keep fighting like anything, poor chaps.
In fact,
State governments just don't care about. Yesterday, somewhere we were just speaking. The real temples of modern India, all along assumed to be infrastructures and dams. The temples of modern India are the primary schools.
Primary school.
Absolutely.
Nothing is more important than primary schools.
Correct.
And we have never learnt to respect our primary school teachers. The way we deal with the primary school teachers, I don't know when the time will come and we'll begin to, they should, their position,
in fact,
status of a
TET
country
itself.
depends on how much respect we give to our primary school teachers.
Actually, my lord, at one time they used to get.
We need to get back. I mean, that's, in fact, our country's future is in their hands.
And now, because we don't pay them enough, my lord, they don't get respect also.
They don't get respect.
Anyway, my lord,
Particularly unfortunate part, regional languages teachers are they don't even get even that much of a respect.
But here, my lord, Bengali teachers, my lord, I found. Well, in fact, TET itself is an
Bengal
innovation.
is also very bad in
No, maybe in
very bad in
electives,
teaching in respecting the school teachers.
Right.
We are not everybody is like that almost. What is to be done here?
my lord, this is a very short matter. My lord. Let me just open it, my lord.
My learned friend, he'll of course open, but Mr. Kalra, I don't know who is appearing.
No, I'm for the petitioners in the main matter, my lord. The office report records. There is a
people have
first
been
matter.
appointed, so he is only
No, I'm
an
sorry.
obstructionist.
No, but
There are 2 matters. I'll explain.
Do you have an appeal?
Yes, my lord. The first matter is mine.
This is
You have a right. And he has an appeal.
Divyendra Kundu, I'm appearing. I'm in that.
Mr. Gupta is for the West Bengal Board of Primary
Doesn't
Education.
matter. You will hear
Who's the appellant?
item 37, right?
Yes, yes.
Indeed.
the Lord-
There are
But I
2.
appear
One is
for
by
the
the board, one is by an individual.
Except for the advocate who is addressing us, all of you take your seat.
Yes, yes.
Yes. Have
Yes.
Take
So
your seat.
TET, my
You
lord.
have a short list of dates, something?
So I have made one.
My lord,
Okay, take that and
my
forward.
lord, just give me 2 minutes. So, my lord, there is a TET examination.
His effort is only to complicate and frustrate.
No.
This objection.
Mr. Patwala.
This is all obstruction.
No,
His
just
people have
all
been
of you.
appointed.
All of
They are all,
In 2 minutes, we will be able to grasp.
all right,
it.
all right.
All of you
I mean,
take your
it's
seat.
unfortunate.
Don't crowd.
That's very unfair, my lord.
What happened?
Well, he's calling me to be that I'm appearing for it to be an unfortunate thing. That's not right. It's my appeal, my lord. There's a stay in my favor.
All right, let him,
comments-
your lord,
What is there in this?
all,
Events are not going to fall in a small matter like this. Why should we be?
My lord, in 2015, my lord, the TET examinations for 2014 was held. TET, as your lordship knows, my lord, section 23 of the right to education.
Tell us one more thing, that does it, this TET 2014, there is a asymmetry from say state to state, is it? Or is there any commonality for all the states across the board? Or each state has its own?
Each state has its own, my lord. And in fact, the
Another
timing also was different because waivers were given to different states when the new act.
Take us quickly through this.
Yes. I can't.
Quickly take us to this fact.
Yes, my lord. Just 3 facts are relevant. So, my lord, after the TET was over, the writ petition was filed saying that there were mistakes in the answers.
6 questions.
6 questions.
Hey, that's the short point here.
Short point. In fact, my lord, if I may summarize it in 1 minute, my lord, without dates.
Yes.
The single judge said that you give. So, first of all, the single judge asked for reports from expert committees. Expert committee said 6 answers were not correct. So, my lord, the court said questions were correct, but the answers were not correct. Then, my lord, the learned single judge said you give marks to, my lord.
Everybody, irrespective of whether they attempted or not.
No, the petitioners. The single judge said only petitioners. When it went to the appeal court, my lord, they said just give 6 marks to everybody, whether they have attempted the question or not.
Yes.
Well, this is in accordance in our submission, my lord, not, my lord, the correct thing to do. We have the relevant records.
You are appearing for persons who have attempted.
No, I am for the board.
Oh, you are for the board.
I am for, my lord, the authority examining. Now, my lord, we have the
Patwalia is appearing.
He is for, my lord,
Persons who
are getting these 6 marks.
who are getting irrespective of attempt or no attempt.
Indeed.
Obviously.
I
Millard,
am those
both, I guess.
Single bench said that the judgment shall only apply. The division bench has said nothing different. Single bench said judgment shall only apply to the petitioners before us.
And all those petitioners before them were those who had attempted or not attempted. There are both sides.
Both sides.
So therefore, irrespective of
yes,
whether they attempted or not, single judge said that give 1 mark each.
Yes. So people who were not parties before the single bench filed appeals before the division bench saying you can't restrict it only to the petitioners. The division bench dismissed the appeal. Then those persons came by way of an SLP before your lordship. In the SLP, your lordship said you are given liberty to file a fresh writ petition raising the same issue. Your writ petition will be tagged with the pending appeal of the board before the division bench and will be heard together.
Okay.
The division bench has now heard the appeal, and division bench says that if the answers are wrong and a person knows that all answers are wrong, he will naturally not attempt the question. It is only if a person doesn't know whether the answer is right or wrong that he will attempt the question. Therefore, the division bench says restricting it only to those who have attempted will be not correct in law. This is the first finding given by the division bench.
Don't argue. Okay, that's right.
And the second finding is give 6 marks to everybody because these 6 marks don't result in any employment. This TET is only a qualification to apply as and when the posts are advertised. We are not getting an employment.
All right.
Now, my lord,
So we are
the very first point which my learned friend has indicated is obviously incorrect. Please see page 62 is the judgment where, my lord, this point is dealt with. My lord, division bench.
72-page judgment.
Yes. Because, my lord, they set out each question and, my lord, all the answers, everything is done.
So 50 pages is the cost title, I believe.
My lord, my learned friend is not correct, my lord. The writ petitioners were those who had attempted those questions.
So how do you...
So that doesn't matter for the time being. Just see this, the crux of the
only
instant
that
appeal.
question as the legality and validity of the division bench directing grant of 6 marks
To everybody.
To everybody,
Irrespective of
whether they have attempted or not attempted.
Exactly.
So at par.
Everybody.
It actually neutralizes.
It neutralizes, makes those 6 questions irrelevant, but my lord, it means that uniformly people will cross the line.
What happens to this exam anyway? 2018 is when was the exam?
2014, 2015 it was held.
So what? All those appointments are now held up, is it?
Yes.
There's a stay by this court.
The appointment will be for future, my lord, purposes. If they have cleared the TET, my lord, then they become eligible to be to apply at any time, my lord.
From 2018, you have frozen it, is it?
No, not frozen.
What happened? These candidates, they have taken TET.
So now if they get
they have to take the TIAT, whatever it is.
No, nothing. TET is enough. TET, my lord, has crosses the bar, then they are eligible to be appointed. There is, my lord, a different, my lord, qualification.
We did some other matter.
Yes.
Where TET is only a qualifying, like a
It is only a qualifying exam.
Then what is the final exam then?
It's a recruitment
After
process.
TET,
only.
my lord,
They have
the
to
selection
have
process starts.
qualification, which is DLED, and then, my lord, there is a recruitment process.
The recruitment process gives marks on the basis
Show us
of
the
TET.
rules.
Now, my lord, just see this paragraph, my lord. It's incorrect from on the face of it. The crux of the instant appeal is as to whether the marks which were allotted for the wrong question / options.
Where?
Yes, my lord, I am at page 62.
Is there any need for us to interfere in this, Mr.?
Yes, my lord.
Is it going to be?
My lord, it creates a problem, my lord, that those who haven't attempted a question is going to get a benefit. Now it's question of 1 mark each, my lord. The moment
Who is getting prejudiced because of that?
Because we are getting prejudiced. If I can just clarify.
Those who have attempted.
We are the
later
ones,
on, they have come later.
We are the ones who are high on merit and who have got clearance without these 6 marks. Now, there's a third angle to this, which is that in the same TET, my lord, there was another writ petition in the High Court where CBI filed a reply.
My lord, just see this paragraph, my lord, it's wrong. My lord, kindly just put these things aside.
Page.
As regards, page 62. As regards to the aforementioned first issue, this court is of the view.
1 minute.
Yes. Last para of page 62. Does your lordship have 62, my lord?
In a minute. Yes.
As regards the last paragraph, my lord. So this is the first ground given, my lord.
These 12 case.
As regards the aforementioned first issue, this court is of the view that those examinees who were definite about the said wrong questions and options which are under discussion might not have attempted those questions, as because the person having accurate knowledge, knowing the correct answer, would not have opted for any of the wrong options because the said examination did not have the provision for negative marking for giving wrong answers. Well, this is incorrect. Why is it incorrect? If nobody would know what is the correct answer according to the booklet that the examiner will use. The problem is, subsequent to the examination results, pursuant to an RTE, they are told that here is the option which has been marked as correct. When the examinee is sitting for the exam, he doesn't know that the answers will be wrong. Because he doesn't know the answer. He doesn't know what answer will be taken as correct or incorrect.
Everybody who has gone to the exam, he is given 1 mark.
Now, my lord, everybody who has gone has been given 1 mark, even if he has not tried.
Today, the selection is on the basis of qualifying marks.
Correct.
So therefore, by virtue of the High Court's division benches order,
Yes.
everybody gets upgraded.
Everybody gets
by 4
upgraded.
mark,
Yes.
and it's only qualifying examination.
Yes.
So therefore, you will have more number of qualifying. It's not going to be an exercise where it's an exercise where to the final examination or a final consideration, you will be having a larger pool of people who are qualified rather than.
But people who are not eligible to be qualified are getting it also. So suppose you haven't answered a particular question, but you're given the mark for it, then you don't deserve to get that mark.
Eligibility in the sense that after having added 1 mark,
yes,
many more people who are at the border
are able to cross and then come to the.
But that's random, my lord. That's random. He doesn't deserve to cross the border. The NCT guideline is that he must.
Not going to cause a great amount of.
It increases the pool for 2015.
Exactly, you're right. It increases the pool.
And after that, my lord, pools have come and my lord.
Leave it
Because I need just a
don't
minute.
need to
There's
interfere in
another
this.
issue, my lord.
Leave it at that. We got your point. I mean, we would not have.
My lord, I have got, my lord.
Because of expediency and this matter is pending for such a long time.
Yes, my lord.
I think it's better.
Look,
that
there's a
we leave it
stay.
at
There's
that.
a stay. Those marks have not been given. There's been a stay from 23. The High Court.
Clear everything.
My lord, what we are proposing.
No, my lord, appointments have also been
If
given.
it comments to your lordship, we have the data to give it only to the persons who have tried those questions. And there is no reason why those who haven't tried those questions should get the advantage. My lord, it will be random, my lord.
No. Today, in
Yes.
this present situation,
Yes.
now the order having been passed and this is only qualifying in nature, we will not let any situation arise where
My lord, this amounts to a large number, my lord. It will amount to a large number.
It is not just a qualifying exam, my lord.
Actually, if my friend's argument is accepted, it is penalizing knowledge. If I am intelligent and I know the right answer and there are 4 wrong options and I don't attempt,
why should they?
I will be penalized.
No, that is not the fact of the case.
Yes.
Okay, anyway, you know,
There are, just see, my lord, 4 options are there.
give us one
Yeah.
chance for us also.
Yes.
See, I don't think we need to interfere in this. We will leave it at that.
Well, can I just take a
Dismiss,
minute?
dismiss.
It's not a qualifying examination.
We'll leave it at that.
Just give me
I
one.
think you should now see there are some cases. It's the experience.
Lord, only one line, Lord, I
If
would
you are a
request.
situation where incompetent people are being appointed, we would have just set aside without any.
But this is incompetence, my lord. Suppose a person
Further
who hasn't
consideration.
answered the question is given an extra.
Board is giving a question.
Leave it at
wrong
that.
answers and contesting.
My lord, my learned friend's
We don't
argument
need
is
to
completely
address each
incorrect.
other, please.
He does not know the answer, which is the correct answer that the board will
You have very
say.
fairly placed before us. Taken that
Lord, only-
situation like
only
this,
one.
Our call to not interfere is the best to.
Can I just take it?
Thank
One more
you.
minute.
Lord,
Take a request.
only half a minute, only half a minute. One line, my lord, for the board, my lord. Why do they set such
Despite my
question
lord's
papers?
the previous order.
All the
Allowing
time
us
this
issue
issue comes.
We are discussing.
Set the wrong question.
There's no application.
Look,
Instead of
just
setting
make
the
one
question,
request.
my lord, they
3
give-
months
they
time,
give
my
a
lord.
puzzle.
After the
Instead of-
elections are over, my lord.
Can I just make one request?
3 months. What do you want, Mr. Gupta?
My lord,
What directions?
3 months
Implementation.
time
Okay.
to complete the
There's
process.
just one last request, my lord.
Commissioner and the
Can I
respondent.
just make one request? Look, nothing should be reopened now because this is a 2015.
We will not say anything, sir.
That, my lords, may make clear because what will happen now if the marks are upgraded, there'll be further petitions to reopen the previous recruitments where they would have qualified because
of any further petition.
So therefore, my lord,
Again, this kind.
My lord, in the previous recruitment is complete. We all got appointment, my lord.
Those who have got appointment, my lord, they'll be told their seniority
Exactly.
will be affected. Of
So
course.
therefore, my lords, may clarify that nothing will
That's
be
just the
reopened.
next round in which Mr. Patwalia
Exactly.
will appear.
So therefore, nothing should be reopened.
Qualifying.
It should be only for future recruitments.
It is on.
I don't understand.
It is on.
We also don't understand that.
Correct. that we have to do something. All of us should work on this.
Correct.
Taking it random. Just we have taken a decision on this. It's not a. To the council for the petitioners and the respondents. They are of opinion that we order. It's not a case requiring us to. Just we'll say. We'll just put it on 136. Keep the question of law.
Yes.
We'll keep the question of law. We will say the special petition is dismissed. However, the question of law raised by Mr. Jyoti Gupta and senior counsel is kept open for being considered in an appropriate case. The facts and circumstances of the case, we grant 3 months time to the state for
Lord,
implementation.
4 months, my lord. This month will go in the kind of
4 months time.
chaos that your
for
lordship is
implementing-
hearing of.
Implementation. What do you want us
The
to say?
retrospective and prospective may be clarified because whatever recruitments have already.
No, we are not going to say.
Lord, what will happen?
No, once we said that. That's it.
I'm just saying what confusions will happen, my lord.
No,
There's some
not
process.
necessary. Not necessary. High Court will deal with it.
So there's nothing pending in High Court. There's nothing.
Go
pending.
back. Nothing more. Nothing. Next.
Great. This is, my lord, the judge's case,
How
where
many
she
judges?
was suspended and 5 years have passed. So we want to argue that she should be taken back now. The inquiry report has come. Keep it on some day where we can argue.
Why? Today is a good day.
Yes, very good. Kindly open, my lord.
Give us a
Kindly
list
open
of dates.
my note for arguments.
You're busy today?
Can it be?
Yes, I'm ready, my lord.
I have a little difficulty. The briefing counsel, standing counsel for Gujarat High Court is not available. I'll file a list of dates and then get ready next week.
Anytime.
Anytime.
All right, next week.
Anytime convenient.
Okay, next week. 29? Better है? 40? वो अच्छा हुआ मैं वो 4 मीटर डिस्टेंस पे
My lords, in item 40, I'm seeking an accommodation. The arguing counsel is in some personal difficulty today. Only for today, my lords.
Not today, ठीक है?
Application for registration in multi-state society has been rejected.
Petitioner will be a multi-state cooperative or not is the one person.
Because they didn't obtain.
Yes.
I'm obliged.
RP is a public servant.
Your pleadings are complete. That's it is a matter, my lord, which arises in execution.
You want to argue? You are ready?
I'm ready.
Then go ahead.
Yes.
Yeah, it should be able to complete it.
It will be over in 5 minutes. I'll take 25 minutes.
You are ready?
Lord, the petitioner, my lord, is arrayed as a defendant in a suit.
He is a
declaratory decree being granted in favor of the plaintiff.
This is the Sanjay Kumar Agarwal, right?
No. This is Kalpata.
That's what you
41.
41. Oh. Okay, we thought that RP. No. Tell us what is this matter about?
The decree, my lords, which is put in execution, my lords, is the relevant page is at page 61. That's annexure.
Whatever. Give us some facts. Who are you? You are for the cooperative housing society.
Yeah, I am for cooperative society, my lords, was the first defendant in a suit. Suit was filed, my lord, by a building tenant. There are 14 rooms in my building. One tenant, my lord, filed a suit for declaration that he should not be forcibly evicted, and injunction restraining forcible eviction. But the building is a 100-year-old building, my lord, dilapidated. Corporation proceedings are there to demolish the building, etc., etc. It is in that background that he filed the suit restraining forcible eviction. So when the suit came up, my lords, the learned trial judge found that the corporation is justified in issuing it because it's 100-year-old and all the other tenants have gone, and that is already approved by the tribunal, and then said no injunction against forcible eviction, but declared, page 61, after refusing injunction, which is at the previous paragraph, no case for forceful eviction in this case. Plaintiff is not entitled to
injunction. Is that item 61?
Page
61.
Yes. Lordship, I'll start from the top of the page. Hence, there is no merit in the contention of the plaintiff regarding forceful eviction.
1 minute. Item 61. 61 is the direction, is it?
Yes.
Read it, please.
Yes, your Lordship may just take the.
It is hereby declared the plaintiff is entitled to be in possession of the plaintiff building.
He'll evicted by the defendant through due process of law.
Correct.
But the previous para, your Lordship may just note that the decree for injunction that he sought against forcible eviction.
The plaintiff is not entitled to get an injunction prayed in the state.
Yes. So therefore, only
the issue regarding injunction answered. So he refuses injunction, but that can't be evicted without due process.
Due process. Therefore, and in the previous
he must be in legal possession.
This is not in challenge. No, I'm not on that. Please. Now, therefore, on the previous page, bottom, your Lordship will find that the corporation has justified in issuing these processes for demolition and statutory. Now, pursuant to this, he files the execution. The building gets demolished without pursuant to proceed.
Despite the order. Despite the order, it gets demolished.
No, the corporation is not a party, to this list.
Okay, that's for some other reason.
It's a landlord-tenant dispute. So therefore, ultimately, pursuant to that, the building gets demolished. He files an EP saying, please put me back in possession, allow me to reconstruct. In that EP, he files an interim application seeking permission to put up some temporary structure. That application is now granted by the learned trial judge, which I carry to the High Court. The High Court, my lords, says clarifies and says that you can only construct a temporary structure. It is from there the matter has come. So we are raising only 2 points. Point one, that it's a purely declaratory decree. And it is covered, Milords, by your Lordship's judgment, Milord. I produced it along with the rejoinder, Milords, so the decision in 98 Supreme Court.
So therefore, the trial court didn't grant him any decree of injunction,
Yes.
but provided a relief that he shall not be evicted
except
due process of law. But how was he evicted without due process?
The building had to be demolished.
Demolished by the municipality.
Building, because there are 14 tenants.
So he lost possession by virtue of some other parallel proceedings.
Yes. So therefore now he has.
So you manage the municipality to throw him out.
I don't think so, Milord. If your Lordship sees exhibits, Milord, annexures A1 to Milord from 2012, because
it's okay, doesn't matter.
Now,
whatever it is. Collateral.
What transpires is, Milord, according to me.
Collateral damage.
According to me, Milord, the EP would have to be decided to find out whether, Milord, there was any violation. One. Two, whether a declaratory decree.
You have to file we have to file a separate suit.
Whether a declaratory decree can be.
This is right, actually. He was a tenant, is it?
He was a building, one among the 14. Now what happens is, Milord, one person.
Has he filed any other proceedings?
No, he has not. Now this one person will now try to construct something in this property. That is the order. I can't now develop the property order.
What was the impugned order?
The impugned order, Milords, now by the Honorable High Court, Milords. Page 5, Milord.
Just read the impugned order, please.
Yes, I'll read it.
From page 3, just a 3-page order.
Yes, if your Lordship.
Petitioner is the judgment debtor. Petitioner is the judge. That is, you went to the High Court.
I went to the High Court.
Okay, doesn't matter. Just read the High Court.
Please have page 3. After quoting para 3, the declaratory decree, para. The learned counsel for the petitioner submitted that petitioner judgment debtor was compelled to remove the building pursuant to direction of the court.
Where are you reading? Para 5.
Para 6, Milord.
Okay, learned counsel for the petitioner.
Petitioner submitted that the petitioner judgment debtor was compelled to remove the building pursuant to the direction of the corporation, which further submitted that though the decree holder sought for the construction of a temporary structure, the court permitted the decree holder to construct a Paka building. Learned counsel for the respondent submitted that the lease in respect of the building subsists. The judgment debtor blatantly violated the order of injunction granted. It is admitted that the building was demolished as per the direction of the local authority. Once a tenancy is created in respect of a building standing on the land, it is the building and the land which are both components of subject matter of demise. Destruction of the building alone does not determine the tenancy when the land which is the site of the building continues to exist. Contention of the judgment debtor that the building was demolished pursuant to direction of the corporation was also taken into account by the execution court. Court came to the conclusion that there was no material to show that the building was demolished pursuant to the direction of the corporation. Execution court further held that the judgment debtor willfully disobeyed the decree. Therefore, this building is to be restored.
Totally outside this, what's the decree?
Further
contention of the judgment debtor that the building was demolished pursuant to that. Okay. The executing court further held that
the judgment debtor willfully disobeyed the decree and therefore the property building is to be restored to its original position. I find no reason to interfere with these findings. Grievance raised by the petitioner is that the court below granted an order, relief substantially deviating from the relief sought by the decree holder. Relief prayed for was to permit to put up a temporary structure for facilitating conduct of its vegetable business. Petitioner has produced certain photographs. Admittedly, building was in a dilapidated condition. Therefore, this court is not in a position to uphold the permission granted by the executing court to construct a Pakka building. Was only entitled to restore.
What is it? It's a vacant land.
It's a vacant, now a vacant land. It's 14 rooms were there. 2-story building. Holding has gone. Now one person alone, Milord, he puts up a temporary thing in the middle. Can't use the property at all for any. My suggestion is, Milord, that the EP is now pending. This is interlocutory stage in the EP. So the EP, they will have to take up and decide A, whether a declaratory decree can be executed. Declaratory decree can be executed.
What we will do.
So what can be done? Court can decide. What I violate.
Lordship, I'm a vegetable vendor. I was running a vegetable shop over there, and he's the one who's demolished the building. An impression is created that it's the corporation that demolished. Behind the orders of the honorable court, they demolish it to evict me.
Have you filed any other proceedings?
No, Your Lordship.
So 1 minute, we'll just tell you something. So far as your decree is concerned, the trial court judgment has become final.
That's it.
You are in the execution stage.
That's it.
The executing court will not go behind the decree. So whatever is the decree in your favor, it will enforce it and implement it. Now the problem arose because of the interim arrangements pending disposal of the execution. We have already granted a status quo and the matter has been continuing since April 2025.
That's it.
What we will say is that interim order will continue. We will ask the EP to be taken up and then disposed of. So
Please,
for
Your
both the
Lordship, I
parties.
have a suggestion. 2 points, Your Lordship. One, the status quo has been breached by them. They are constructing now.
You raise all those, please, before
Second
the EP
point.
court. Huh?
Second point, Your Lordship may consider, and I've taken instructions, perhaps if there can be a mediator at the local level.
EP court.
This can be an issue that can be solved. Otherwise, it will be a protracted litigation, Your Lordship. I'm running a small vegetable shop.
You will stand or fall on the basis of the decree that you have got. So you will have to contest the case, okay? The special petition, leave granted special petition is against the judgment and order for Karikana. The respondent obtained a decree from so-and-so court on 27/7/2016, relevant portion of the judgment of the trial court is as under last two paragraphs, pursuant to the judgment of the trial court, the respondent initiated execution proceedings before the trial court. Pending disposal of the EP, he moved an interlocutory application asking for, what was the prayer in that EP?
For restoration of possession.
For restoration of possession. Instead of considering that application, on consideration of the said application, the executing court, by its order dated 9/2/2018, restrained the appellant from making any further construction and also directed the respondent decree holder to put up construction as what did you say? Construction as original building stood. What is it?
With the same area and height.
Put up construction. What is that?
Page 85.
Page 85. Put up construction as original area.
In the decree scheduled property with the same area and height.
Oh, that language is not correct. What is that?
Page 85.
Page 80?
PDF 123.
Page 80 what?
PDF 123, page 85.
85. Direction. As under para 9 quote kar lena. Para 9 hai, page 84. Questioning the above said order, the appellant filed a revision before the High Court under Article 227 of the Constitution. Partly allowing the revision, the High Court directed as under para 12 and 13 quote kar lena. Paragraph. In the special petition filed by the appellant, this court directed the parties to maintain status quo pending disposal of the special petition. In view of the fact that the order impugned before us is interim in nature, pending disposal of the execution proceedings, we are of the opinion that the status quo order granted by us may continue for some more period, and in the meanwhile, the execution petition can be taken up and disposed of. Paragraph in view of the above, we allow the appeal, direct that the party shall maintain status quo and till the disposal of the execution petition. In the facts and circumstances of the case, it's also necessary to direct. We also deem it appropriate to direct the executing court to take up and dispose of the execution petition expeditiously, preferably within a period of
I've also
6 months from today.
I've filed a contempt petition also because Your Lordship, they're in breach. Your Lordship may dispose that off also.
Yeah.
Yes, I have.
Our order will dispose of even the contempt petition filed by the respondent. Thank you.
Great.
My lords, the next matter 42, my lords.
42.
There's an in a pending matter before your lordship, leave granted matter The date in the trial court now is tomorrow, my lords.
Sanjay Kumar agar
Yes, my lords. It was mentioned and listed by your lordships, my lords.
We'll take it up next Tuesday.
Because tomorrow is the date in the trial court.
What for?
They'll take cognizance because till your lordships granted leave, nothing happened. But the day your lordships granted leave, the sanction for prosecution came.
What do you mean granted leave? We granted leave.
Yes, my lords. On the question
Why
of,
is it coming on a miscellaneous?
because my application for stay is coming up because on that very day, my lords, the board, IBBI granted sanction for prosecution, and the trial court has now listed it for taking cognizance and proceeding further. Till that day, nothing had happened. From 23, the sanction was pending.
Who's appearing for the respondent?
The CBI.
Who is appearing?
In fact, the sanction itself says that it is subject to the outcome of these proceedings. It can be taken up next Tuesday.
No, the date is tomorrow.
Nothing is
Whether the RP is a public servant or not, he has
Yes.
to be a public servant. Where is the doubt about that?
But anyway, till such time that you're not,
not be a
till
president.
such time that you're
Red-handed.
Not on the merits of the matter.
till such time your lordships decides that, my lords, after hearing, because there's one judgment of Delhi High Court.
What will happen if you appear, if you go there?
No, not appear.
Inside.
The trial will commence, my lords.
Let it commence.
But as a public servant, were your lordships
So
to
what?
But were your lordships to take a different
We
opinion?
take a prima facie view, Siddharth.
No, I'm not saying that. I'm
Take
not.
the prima facie view.
I'm not-
We are prima facie.
There are two appeals before your.
Dealing with public funds.
My lords, there are two
Know
appeals.
how
before-
important an RP position is.
I know, my lords. There are two appeals before your lordships. One from Delhi High Court where I have lost. There's another from Jharkhand where the CBI has an appeal which says he's not a public servant. There are two conflicting opinions, my lords.
Stop application, not necessary.
My lords, kindly, if he's not a public servant, then to face prosecution of
Phase doesn't matter. We will
the
quash it.
Prevention of Corruption Act, my lords.
Doesn't matter.
The entire prosecution. Anyway, please have this. Then have this.
Have it next Tuesday.
Lordship, please.
Lord, item 55 is the time fixed matter today at 2 p.m. This is that matter, my lord, where I
Arbitration.
arbitration.
Specific performance.
That's right, my lord. And the difficulty is the NCLT is going ahead. Your lordship has expressed a prima facie view. I'm not going there. But the whole foundation of the order of the High
Want us to do?
My lords, if it could be taken up tomorrow, my lords, 2 o'clock.
Final hearing day.
Well, my lords, then the earliest day, my lord.
How long will it take?
My lord, I will not take more than half an hour, 45 minutes.
Then it's not a case for miscellaneous.
My lord, the difficulty is this, my lord.
We understand. We understand.
My lord, only just one thing. My lord, the foundation of the judgment of the High Court is that 2018 amendment is retrospective. It is authoritatively held. It is not. That's the whole foundation, my lord. And that termination, my lord, let it be on the 14th, my lord, if it's on to come up on a Tuesday. Because we're not
May I mention fresh matter? Fresh matter.
take up the matter, my lord, and I'll once I'm
Fresh
my lord,
matter.
We will call upon the council, then you can speak. Everybody don't speak in a random. We will call on you. You don't know, Mr. Tripathi.
plus 14th, my lord,
If it's 14th, are you talking about?
14th April, my lord.
14th.
That will be a
Fresh matter.
Don't shout like that. We just, ma'am, tell
Lord,
us. We are calling each one, please.
I apologize, my lord. I'm told 14 maybe, my lord, Ambedkar Jayanti.
Please don't take more time. If not 14th, next Tuesday.
Oh, very well.
Malus, item 59, Malus, fresh matter, Malus. Malus, we have Silpi, Malus.
Shall we take it up now?
Please, Malus.
Rest of the matters, if at all, will come on next Tuesday.
Lord, for item 62.
Tell us.
Lord, 62, I appear for the respondent.
Granting,
Yesterday's order.
directing the state CET said fill up this thing.
Well, it's in
Vacancies. So we have discussed the SLP yesterday. It is in respect of your.
Similar matters were dismissed actually.
no, Malus.
Yes,
Malus,
we-
there is no similarity, Malus. I have appeared, Malus.
Interim order, same interim
Exactly.
order.
Malus, the
directing-
issue is different, Malus. Just 2 points, Malus. 2 points, Malus. Malus, the High Court has allowed the counseling at an institution level, Malus. That is not allowed, Malus, as per the Act. And second, Malus, the High Court has given permission them through a state act, Malus. There is a central act, Malus. Malus, there is similar order which Malus has issued notice, Malus.
Similar matters we have dismissed, we have kept the
Malus,
order.
there is no similarity, Malus. I have appeared in these matter, Malus. I have the copies of these orders, Malus. Malus, the institution counseling is not allowed as per the act, Malus. And as per even the state act, there is a central act already, Malus. Malus, moreover,
Said, did you see our order?
please, Malus.
National Medical Council's order. You are appearing for whom?
I'm for the petition, Malus. National Commission for Homeopathy, Malus.
Same order. Same
Malus,
dismissed.
Malus, may I just point out, Malus?
I have the copy of these order, my lords. I have appeared for the petition, my lords. The issue is different, my lords. That is for the students, my lords. I am saying institutional level counseling is not allowed as per Act. The High Court order is completely contrary to the Acts, my lords. As per State Act, my lords.
Did you not, don't you remember, we have said that court has been passing orders, right or wrong. We said that so far as this academic year is concerned, because large number of such orders have already been passed, we have said that in this case, in this particular year, we will leave it at that. We have also directed the court not to pass any further orders with respect to other institutions.
My lords, in this matter, this is for the present academic year. Now then, for the next academic year, 26-27, the admission process already started, my lords. Now, my lords,
This is for which academic year?
this current 25-26.
Previous one was which academic year?
I'm sorry, my lords.
25-20.
The one which we have dismissed it.
That of 22-22, where the students, they have taken, they have attended classes for 2-3 years, my lords. Now this is for 25-26, my lords.
That's also 25-26.
25-20.
No, my lords, 20.
Was listed yesterday, my lord. This is
Yes, yes.
25-26. Verify that and then tell us.
Please, I am appearing for the commission in both the matter. How it is possible, my lords?
you don't give it in that also, my lord.
Lord, I am
Yes,
appealing for the respondent.
Sure about that?
I'm sorry, my lords.
That is, you're talking about this particular case.
25-26 admission process is over, my lords. NEET has been announced for the next academic year, my lords. Later on,
Yesterday's matter also, it was academic session 25-26 matter.
my lords, I am appearing for both the commission, my lords. It is not in my,
That is not 25-26.
Not
Verify
25.
that
Deep
and
see,
come
my lords,
back.
this, I am for the.
Okay, verify that and come back. We'll take it up tomorrow.
Please, my lords.
Lord, may I have your lordship's indulgence? Item 62, prayer is
Wait a
only.
minute, wait a minute. We are calling 60 now.
Lord, 62 I am for the respondent, Lord.
60. Who is appearing in 60?
60, I am appearing.
Come.
But,
Hockey matter.
yes, the order was
Hearing
absolutely
order.
right. There was no reason to modify it. The reason is that we are the only.
But they permitted you, except that they have said that you will not display it. That's all. That's the
No,
clear direction.
our association is the only registered, recognized association under the 2005 Act of
That they will
Rajasthan.
decide, Gopal. But what they have modified that order
Correct. They
is
have
only a limited modification.
no, they effectively are players.
Except that,
Yes.
they have said that.
If your lordship sees page
Seen that,
76,
seen that.
page 76 was what was prevailing earlier. That was the interim order.
We know that.
Now
We
76,
have got both.
yes, at page 78,
Correct.
says it's
Meanwhile,
directed
until
to
order,
permit
order number 3, Hockey India. is
and the players affiliated with it to participate.
Gopal,
Now-
see here.
Yes.
1 minute. Hockey India is directed to permit the Hockey Association and other players affiliated with it to participate in the national. Till here, there is no change. Then also, we display the name. That's the one change.
Yes, that's the direction regarding display of the name of someone. Now we are the only, under the 2005 State Act, we are the only association who have been registered, recognized from 1950. From 1950. Some,
Para 3 of the impugned order C. That's
Yes.
what it
That's the
refers
reason
to.
for modification.
yes, that is because of, I know. That is Justice Rastogi's order when he was the judge there with reference to affiliation to Olympic Association. That has nothing to do with our recognition and registration, which is intact. Under the Act, under the state enactment, just hand up copies. I'll just show your lordships the two clauses. One is under the state enactment of 2005. In fact, it's extracted also at page G. Page G for a minute.
They're balanced, Gopal. We are
No,
not
Manoj,
comparing
there's
it.
no balance. I get 0. There's no balance. At least balance would mean that my team's
Only thing that has not been granted